The petition is dismissed.
Let's.
It's showing ID.
Item 1, PL Shumotu 1/2020.
Do we expect a farewell of this today?
My lord?
Do we expect a farewell of this today?
Yes. Like what your lordship had said last time, that everything should come to an end one day. So I think we are very close to that, at least us.
Oh, very good.
It's been a very arduous and very long journey on both sides.
No, for you, we don't know, but for us, it
I-
was.
We only pass on the buck. That is the thing. And the actual responsibility is your lordship.
Yes, sir.
Please. My lord, I'm not repeating any of my past submissions. So what I'm briefly touching upon today is what are the facts on which there is no dispute? Which I may call it as uncontroverted facts. Yes. Please. The first undisputed fact after a lot of deliberations is regarding the ownership and transfer of land and its resources, the ownership in terms of 371A. This fact was considered on 27th/28th July 1960, when there was discussion between the Foreign Secretary and the Naga National Council. So one fact which he himself said was that
27 July 1960.
27 and 28th July 1960. This is all on base of records which 27th and 20th July 1960.
This was minutes or this was agreement,
So discussion
discussion.
between the Foreign Secretary and the then Naga National Council. So there, he made a categorical statement that there is no intention to disturb the underground resources. Very, very clear. Lordship may say it's a discussion for it. It is pursuant to this discussion, because I'll just briefly inform your lordships. Before the amendment was introduced in the parliament, because the amendment is based on these earlier agreements, 9 point, more particularly the 16 point. So they wanted to have a recheck between the Naga people and the central government. So they had a discussion on each point. Many of the points, there was agreement, where it is certain we agree. Many of the points, no, there is no agreement. So on this aspect, which is clause 7 of the 16-point program, which deals with land and its resources, transfer and ownership. On this, the Foreign Secretary himself conceded that we have no intention to disturb these resources. And it is thereafter, the matter went to the parliament. And in the minutes also it was mentioned, it's a discussion. Final arbitrator in the matter will be the Prime Minister. So this was the fact. And that time, the then Honorable Prime Minister pointed out, we won't let you down. We stand by what you say. And thereafter, we have opinions of jurists. We have so many other things which I have brought to your lordship's notice earlier. Ultimately, the present position of Union of India is we are not touching that question. So it has ceased to be a point of dispute. First. Next, my lord. The next question is, does the Parliament have the power to make a law which in any way interferes with Article 371A 1 to 4? Or is there an embargo? In my respectful submission, this is also settled. A mere reading of Article 371A says no act of Parliament will die. But I don't want to go just by that interpretation. The same Foreign Secretary and Naga National Council, when they met, the Secretary introduced a new concept. He said, what about this 53 and other things, 53 and 54? You will be subject to that. He did say that. They had a farsight at that time. What about 53 and 54? The Naga representative did not agree. And already at that time, these acts were already passed, on which we are discussing today, because they were passed in 48 and 56. And we are talking of 63. So the clarification was made by the then Prime Minister that we will not touch it. We won't disturb it. He also said you have the liberty to make your own rules. More importantly is the version of the then Law Minister, Ashok Sen, who summed it up in a very simple way when he said that the whole scheme of the bill is that no law of the Union of India will have automatic application to the new state. They will apply only if they are so applied by the new legislature of the new state of Nagaland. That is the whole scheme. This is what is there as even what the law minister had said at the time. Further, I would crave reliance upon there are two opinions which the government is relying upon. I said both by the same minister in different ministries, where the first opinion, they say that we won't interfere. You have the right to make the laws. Second opinion was the opinion of the learned Attorney General. He was in favor of one point, he was not in favor of another point. The point he was in favor, that was very categorical, because he says laws made by Parliament under 53 of the list shall have no application in the state of Nagaland unless the Legislative Assembly decides to extend the application of such laws to the state by way of a resolution. This is one part which is in our favor. I am talking of that particular part. There is a part against, which I will read when I come to that point.
You can just briefly state it because that's you have already argued.
Yeah.
So you can just give it because we have all made extensive notes.
Yeah.
So you can just give a short point so that.
Yeah, so what I'm trying to say is this point, that the Parliament cannot make a law on this aspect, has been settled from the inception in 1962 or 63 to the Attorney General's opinion, to the different opinions given by the various jurists, to the version given by the Law Minister. So in my humble submission, there is no more dispute on that. Thirdly, in this
Are
type of
you saying that the union government cannot make law, or you are saying that union government may make law, but it will not be applicable?
the union government, the version of the jurists is beautiful. They say they have the power to make laws under the Constitution for any of these provisions.
So it will not be applicable.
But as far as the state of Nagaland is concerned, it will have no applicability. Power, we cannot challenge that power. Power is there in the Constitution. But what is excluded is an amendment which came post these acts, in which they did not make any further clarification. The next point, my lord, is thus the Legislative Assembly of Nagaland, is it endowed with power to make a law? That's the third question. Because according to the opinion of the Attorney General, though he says Parliament cannot make a law, he also says the Nagaland Assembly also cannot make a law. He says that. Now, in this connection, I've already emphasized, I don't have to repeat, that under 371A, the source of law begins with that. When they can even stop an act of Parliament, it is not an ordinary letter or order, it's a constitutional provision. So that right is there, embedded in the Constitution itself. Interestingly, there is no analogous restriction specified in the Constitution that the Nagaland Legislative Assembly cannot make a law. Very clear. One is very clear, you don't have the power. And this competence has been upheld by the views of the various jurists on this. And in deference to this, what was the submission of Union of India, my lord? We are not touching the first part, ownership, transfer of land and resources. Then what are you touching? We are touching on the limited aspect of a restriction. Not a restriction, a regulation, I stand corrected. And that regulation touches 2 points. One is inflammable substances. The other is public interest.
One is inflammable substance. Second is
Public interest. In public interest, they can make certain regulations. These are the ingredients of entry 53 and 54, the gist of that. As I mentioned last time, inflammable substances, we have to be careful. Who says no? Public interest has to be respected. Who says no? But does this clothe the central government with the power to nibble with the revenue? That is the issue. Nowhere that power has been given. That right is given to the owner. And as I mentioned earlier the contract was such production contracts where the expenditure is first taken out and the revenue shared. And now it is revenue contract. Right from day one, when the oil comes out, the sharing has to start. So does that intention or that act interfere with Article 371A? Now, my lord, I would take your lordships to the 9 judges bench judgment at page 108. Only 3 lines I'm reading. I'm giving that separately to you. Page 108, my lord. Is it para 170? You sit there, yeah, sit there. Work. May I read it for my lord, my lord? My lord has got his page. Regulation and
We are
development,
reading which paragraph?
page 108. Yeah, I'll just- that will- yeah, page. Just 1 minute. You mean the judgment?
Is it paragraph 266? Last time you had
I'll just,
royalties to be paid to the proprietor.
I will just see, whether just 1 minute. What is the page number given here?
Page 10.
One,
Page 10.
You know whether you want to leave this,
just a minute.
172.
Eh?
Want to show this one.
No, no, I'm just coming to. I will just take it out in a minute, my lord.
You were seeing page 108. So see this one. This one. Para 172. Worship of land.
Oh, yes. I will just take it out, my lord. Bear with me for a minute.
It's okay. You can sit down and find it
Yeah.
out.
In the context of nominating versus 172.
What will be the-
The quotation where this is something that she's added. So this is not in the charge, but
Which one?
so from the two, with 172, she's added these three elements.
No, she has not. Because the printout of this. No, the judgment. Take it out.
This is the value.
What she had typed out certain paragraph. Where is that? Well, page 108. Which is it?
So 108. I will just. So this is the paragraph she's added 3 lines.
I will recheck. Explain to Lordship. But-
As per our notes, you referred to this
Yeah.
to show two things. Number one, what is land?
Right,
And then you say that this, the resources of the land
please, man.
would be either, if the land belongs to the government, then resources belong to the government. If it
Right.
is a private land,
It
then the
belongs to-
resource belong to the private person.
I'm having that in, your Lordship must be referring to para 172.
No, we are referring to our notes.
Okay,
Uh,
that is in 172 paragraph, it's a verbatim this thing. That ownership of land includes ownership underlying minerals unless the right to minerals has been expressly reserved. I'll just come back to my submissions.
Yes,
We'll recheck.
yes,
Till then, I won't read what I have written here.
yes.
Then, my lord. I was on this point, that whether development and regulation can go to such an extent that you can take away the revenue of the state. Therefore, my lord, I was constrained to bring to your lordship's notice the different avenues in which after pleading that they will not interfere with the ownership and rights, they are precisely doing that. Precisely doing that. The effect of that is they have taken the plea that these entries are a part of the basic structure and they have eulogized the principles of federalism. There are decided judgments which speak as far as the entity of the state is concerned. In the garb of federalism, you cannot wipe away the state's interest. Therefore, my lord, I'll give the exact paragraphs. I don't want to commit an error. So this is also based on this very judgment, where they say that as far as federalism is concerned, state is also just see 276, so we don't commit a mistake. Two 276 page. Okay. I will just read one paragraph and then I will give the citation. This has been repeated in many decisions. The fact that under the scheme of our constitution, greater power is conferred upon the state and the center vis-a-vis the states does not mean that the states are mere appendages of the center. Within the sphere allotted to them, states are supreme. The center cannot tamper with their powers. More particularly, the court should not adopt an approach on interpretation which has the effect or tends to have the effect of whittling down the powers reserved for the state. The state has its individuality and you just cannot take it away. This is in para 48, my lord, which I am reading out. Federalism. Actually, S.R. Bombay case. And in that, they have quoted from S.R. Bombay in para 276. The exact what I have read out to your lordships. So therefore, my lord, the various decisions where they have tried to gain the support of federalism, all those decisions are applicable against them. They acted in letter and spirit against federalism. Then, my lord, the next question is repeatedly quoted. We are tinkering with the constitutional provisions, introducing certain provisions which do not exist. This was their main allegation. Now, who has been tinkering, my lord? Their submission that Article 371A, there is a dichotomy. 371A, 1 to 3 is on one side. That is all the customary practices, religious practices, the laws, etc. While 371A 4, Roman 4, which deals with ownership and transfer of land and resources, is on the other side. So they have stated, state can make laws. So they are conceding that under this provision you can make laws. But only with respect to 1 to 3. Why? Because according to them, that comes in the legislative list. This is their submission. While 371A4, which deals with transfer and ownership, that doesn't come. So we are the masters of that. This type of interpretation is not there in the Constitution. Not there. This type of discussion even was not there in the entire debate in Parliament. And if we see 371A, 1, 2, 3, 4, they are not disjunctive, they are conjunctive. They apply to all the four portions. So to suit their needs, they cannot say 1 to 3 is one portion, 4 is another. And for this purpose, we have to see what was the intention. And the intention can be gauged by the various debates in the parliament, where there is not even a single reference of this type of bifurcation, not a reference. So a bifurcation in the court cannot be considered. What has to be considered is what was the intention of the parliament at the time the amendment was conceived. Therefore, my lord, when the law minister himself has categorically said this is special, he won't come into it. Are we today entitled to ruin the economy of a state which has stopped production for the last 31 years because of facing this unfortunate trauma of the center walking away with the revenues? So if they laid their hands, their eyes on this, that means in letter and spirit, they have breached Article 371A. It's completely against law. And for committing this breach, they have camouflaged the breach in the garb of regulations and creating a misplaced apprehension in the court that suppose we sell the petrol to China or we send it to some neighboring country. These are all misplaced apprehension, and they should be aware of the fact that we are having huge trade with China, where our exports is only 15% and our imports is 85%. We may have differences, but in trade, we have to control each other. So these are all misplaced apprehension. He has to show very clearly that, see, it will affect an inflammable substance that can be considered. And what is this public interest, my lord? When something does not belong to you, you walk away with the revenue. And in writing, you categorically say that I am the owner, central government. And the state of Nagaland, there is not even a column in those agreements to put a signature. Keep quiet, you take so much royalty and your royalty will keep coming down. As I had mentioned to your lordship, the exact practice which is happening in the African countries, which is now stopping. So what are we fighting for, my lord? What is this whole dispute about? We are talking of constitutional provisions, 9 digits and so many other things. It's actually the revenue. The state wants to get a reasonable amount of the revenue. It is willing to share the revenue. That's a different thing. To just wipe out that and then come and say we are only using restrictions, which even I was very impressed by when he first said that it's for this purpose, that purpose. I was telling them it's very reasonable, the argument. But when you go further, that is not it. They've traveled beyond that. So they have to answer this question, what was the basis of them to claim the revenue? They have not answered that. And in this matter, they should answer this very concept. My other point is, which I have already spoken about earlier, is Article 131. I think I have dwelt upon it. I made a small paper book for 131. And also even today's submissions and some more which will come from the other side. Dear my lord, I'm not repeating how they take the land and give a pittance, 2% catering business, civil contracts. I already mentioned all those details to your lordship. Is this what an owner gets, my lord? This is what an employee gets. Very sad, my lord. 1 lakh for village development, sharing production data. They are not giving. Then, my lord, there are judgments which say the historical aspect cannot be obliterated. Very relevant. Basically, for your lordships. The union cannot forget under what circumstances 371A was given to the state of Nagaland, and only to the state of Nagaland, not to any other state. That to post these acts. We have to trace back to the Battle of Kohima, when the Japanese forces came. Naga people were not belligerents. They fought for this country. They fought. They lost lives. Even women with kitchen knives fought. And British have accepted the fact this is the greatest battle they have fought, hand to hand. Then they made their demand. We are separate, you must give us. When the government did not give, they went on a non-violent protest. They went for first a plebiscite, boycotted all the elections, and the atmosphere was of a Cold War between two dangerous neighboring states. It was in that situation the government said, come forward. We will consider you. You be part of the union. We may not give sovereignty, but we will give you these privileges. And these privileges which others are envying, ownership of land and resources, was nothing compared to the state of Nagaland agreeing to remain with the Indian Union. And as I pointed out of, I think, 565 princely states at that time, though Nagaland is not a princely state, it was not under the suzerainty of the British, Mughals or Hindu kings. They had said that only Goa, Kashmir, Hyderabad, some of these were resisting, they overpowered. What did they do with Nagaland? The famous peace talks they initiated by the center, where they gave a very decent nomenclature to those who were fighting for it, saying they are underground factions. And that is kept alive from 46 till date. And in world history, it has been recognized as the longest peace talks in the whole world, in the whole history. So when you have brought them up with this, giving them so many assurances, can you turn back today just for getting some small revenue and tell the Nagas, no, we cannot give it to you? That would not directly. The garb of these regulations, which do not provide and which cannot provide, that you can take away the revenue. And taking away the revenue is not mentioned. They don't get any power under any law. So therefore, in my humble submission, it is an unfortunate act which the central government, in the guise of various provisions and various entries, is trying to defend themselves. It's time they see reason, my lord, because they have to accept the fact what belongs to the people given by the Constitution should be given back to them. That's my humble submission. If any judgment or anything is coming, I'll carry it and give it. I'm obliged.
Minute, so far respondent number 7 is concerned,
we are along with learned advocate general, my lord. Now, my lord, we are dealing with the state, that is the state of Nagaland, which had been given a special status. That is the 13th Amendment 1962. As your lordship now has come to know, the state of Nagaland has emerged through a political agreement, that is clause 7 of 16-point agreement. My lord, I'll just try to take your lordships to that. Already your lordship has been taken to that. Lord, these clause 7, ultimately, my lord, it has been crystallized into Article 371. Where are those papers? First I'll try to take your lordships to the statement and objects and reason appended to the Constitution. Why this enactment, the constitutional amendment was brought into. Yeah, well, this is the very basis why this amendment has been brought. Statement of objects and reasons. In July 1960, an agreement was reached with the Government of India with the leaders of the Naga People's Convention, under which it was decided that the Naga Hills Vanshang area, Nagaland, which is at present a Part B tribal area, within the state of Assam, will be formed into a separate state in the Union of India. The agreement inter alia provides the governor of the state of, well, the lordship may skip that. The lordship may see D. Act of Parliament shall not apply from there. Act of Parliament shall not apply to Nagaland unless so decided by the Nagaland legislature with regard to religious or social practices of the Nagas, the Naga customary law and procedure, administration of civil and criminal justices involving decisions according to Naga customary law. 4, we are concerned with that, my lord. Ownership and transfer of land and its resources. Then, my lord, in the next page, clause 3, as these matters are peculiar to the proposed new state of Nagaland, provision with respect thereto has to be made in the Constitution itself. This bill accordingly seek to amend the Constitution to provide for the aforesaid matter and matter ancillary thereto. This is very important, man. A separate bill for the formation of the new state relatable to Article 3 is also being introduced. Now, Constitution, that is 13th Amendment 1962. Then your lordship will find short title and commencement. Then your lordship kindly see B. Temporary, transitional and special provisions. After Article 371, the following article shall be inserted, namely, a special provision with respect to the state of Nagaland. We are concerned with, my lord, clause Roman 4. Ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by resolution so decides. But in the instant case, my lord, your lordship has already seen that the state of Nagaland taken a resolution saying that so far the Parliamentary Act is concerned relating to entry 53 and 54 of list 1, these are not applicable in the state of Nagaland. They have taken a positive resolution And by virtue of that, your lordship will find the Parliamentary Act has no application so far state of Nagaland is concerned. Therefore, my lord, your lordship at this stage can look into, my lord, entry 18. This is can be said to be corresponding entry to 53. And entry 18 is not controlled by the list 1. Is a free entry. Therefore, it is in regard to land. My lord, I will take your lordship to the certain decision of the appeals court, the constitutional bench judgment. Land includes, my lord, above and beneath the earth. So whatever the resources there, this will all belong to the state of Nagaland. And as Article 371 can be said to be an enabling provision, my lord, the expression, my lord, as your lordship is aware, the law can be framed not from the express words of the Constitution, but sometimes by implication. So 371 can be construed to be an enabling provision. And your lordship will find, my lord, while enacting this 13th amendment, well, the Constitution framers were conscious of the situation that there is an entry 53, 54 of list 1, as well as entry 18 and 23 of list 2. My lord, 18 is a free entry. So far entry 23 is concerned, it is subject to list 1, but by insertion of 371A, that subject to list 1 gets eclipsed. So therefore, the 23 also that way, my lord, in terms of Article 371, that is also free entry. Therefore, the state legislature has complete and plenary power to make a legislation on that subject. And since, my lord, your lordship will find the line of demarcation with regard to lawmaking power of the parliament, as well as the state legislature, has been specifically given in the entry. And my lord, the constitutional framers were very much aware that supposing, my lord, the Central Act is not applicable, in that event, my lord, a situation may arise to make a enactment so far the state legislature is concerned. And therefore, your lordship will find there is no bar under Article 371 that state cannot make any legislation. Because ultimately, my lord, the enabling provision is 371, and by taking the whatever your lordship may say that it is enabling, I will say it is enabling provision, and therefore the state legislature can make a law. And the subject ownership and transfer of land and its resources, my lord, your lordship will find the constitutional bench judgment. I'll take your lordship at the latter stage. Now, my lord, further any contrary interpretation in regard to Article 371 will ultimately lead to the entire constitutional amendment in OTOs. So therefore, my lord, we are to see that now, my lord, I will take your lordship to Article 371. Oh, yes. Well, your lordship, kindly see Article 372, how it is worded. (371) a special provision with respect to the state of Nagaland. The opening word, this is a very important, my lord. Notwithstanding anything in this constitution, my lord, this word itself shows that it overrides the other powers of the constitutional provision. Now, notwithstanding anything in this constitution, no act of parliament in respect of, my lord, I am not reading 3. Your lordship may see the Roman 4. Ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by resolution so decides. Therefore, my lord, it is emphatically states that unless there is any resolution that the Parliamentary Act will be applicable in the state of Nagaland, my lord, the central laws will have no applications so far the state is concerned, which will give the way to the state legislature to make their law in the subject petroleum and other things. And in regard to that, my lord, I will take your lordships to Article 245 because these phrases are very important, my lord. Article 240. I'm reading Article 245. Subject to the provisions. My lord, the phrase is subject to the provisions of this constitution. Parliament may make laws for the whole or any part of the territory of India. The legislature of a state may make laws for the whole or any of the state. Now, your lordship will find this power is absolute so far the parliament as well as the state legislature. And so far 246, your lordship will find this is the field of legislation. So for 245, my lord, nobody can tinker with that because the legislative power is with the parliament as well as with the state. Now 246 is a field of legislation and it can be, my lord, interpreted broadly to give the meaning of the constitutional amendment. So therefore, if your lordship look in the entries, as your lordship has seen 53, 54 of list 1 and 18 and 23 of list 2, my lord, with the insertion of 371A, so far 18 is a free entry as your lordship. Your lord, so far 18 is concerned, your lordship, I'll take your lordship to that first. The list 2, my lord. First, your lordship can see the list 1, 53 and 54. '53 talks about regulation and development of well fields, mineral well resources, petroleum and petroleum products, other liquid substances declared by Parliament by law to be dangerously inflammable. 54, regulation of mines and mineral development to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient to the public interest. Then the corresponding provision, I will take your lordships to 18 and 23 of the list 2. Your lordship may see entry 18, land, that is to say, rights in and over land, comma. My lord, we are on that. Land, that is to say, rights in or over land. Then your lordship may see entry 23, regulation of mines and mineral development subject to the provision of list 1. Now, this subject to the provision of list 1 the
1940, 57, we are in যখন খেতে যেরকম ইচ্ছা হয়
my lord.
One fact has been made clear by the 9 judges bench.
Yes.
The 9 judges bench, the whole discussion is interrelationship between entry
Madam.
23 of list 2 and entry 54 of list 1.
Right.
It has nothing to do with entry 53.
Right.
54 entry of list 1
Right.
is relatable to entry 23 of list 2.
Yes,
The whole discussion,
right.
right from very beginning till end, it is on 54
54.
read with 23. Nothing related to 53.
Your Lordship is very right, because that was.
Because we do not have to deal with entry 23.
No,
It has to do with, I think, 18.
18. And so far, 9 judges' judgment, but it is in regard to whether royalty is a tax or not.
Huh.
In that context, the judgment was delivered. But certain things, 23 was not the subject matter. The honorable judges were never called upon to discuss about that. So therefore, your Lordship is missing that part. It's not there. Your Lordship is
So far, the discussion regarding land and its resources,
right.
we can take benefit of the 9 judges bench.
Exactly. Your
But
Lordship is very
that 54 and 23, that discussion we have to explain.
yes, yes.
That is what I am saying.
Yeah, your Lordship is very right.
So for land and its resources,
Right.
we can take benefit from the 9 judges bench.
Yes.
But interplay between entry 54 of list 1 and entry 23 of list 2, we have to skip it because
Exactly.
oil, mineral oil is different, mines and minerals are different.
Yes. I endorse the view. It's exactly that's.
Because if that view is accepted, then you see the discussion on entry 18 would not come.
Yes.
Because 18 relates to residuary entries with regard to land tenures, landlord tenant.
No, your Lordship may see, so far 18.
Paragraph 7 of 9 judgment of highlight.
देखे ना आगे There are 6. That's why here it is para 6. This is on them.
Our understanding.
Well,
So it will be entry 53, list 1, entry 18, list 2,
Yeah.
land, and rights in or over land,
yes.
and Article 371A 1D.
Well, I will confine to that one.
I think
Yes.
our discussion will be limited to these points,
Yes.
the interrelationship, interplay, and which one will prevail, which one will not prevail.
Entry 23 also, mines and mineral.
Mines and mineral oil are quite different.
Below-
And we are concerned with exploration of mineral oils, which includes petroleum and all other.
Now, there are 2 acts, my lord. One
Let
is
us
to-
see that Mines Act and Oil Field Act.
And also, my lord,
Thus,
Mines and Mineral Act 1948, the
Huh.
pre-constitutional act.
now see now the present one. Mines and Minerals Development Act
1957.
57.
57 is the present one.
Clause
And in regard to, my lord, as a lordship posed me a question about 53.
Ah.
That was not a referred entry. If your lordship look at section 6, I mean paragraph 6 of that 9 judges judgment.
Yes, that is why I am saying it has not discussed 53.
Yes. Because
That is what I am saying.
right.
That it has discussed the interrelationship between entry 54 of list 1 and entry 18 of list 2.
List 2. And
20, sorry. Entry 18 also
Yeah.
and entry 23.
23.
So 54 of list 1 and entry 23 of list 2 does not have a direct bearing in our case. It is entry 53, if I have understood correctly, subject to correction, of list 1, entry 18 of list 2, and Article 371A 1D, land and ownership and transfer of land and its resources. I think this is the line.
My lord, so far 54 is concerned.
Ah.
It has got some bearing. I will take your lordship to
So
that.
far, the discussion in the 9 judges band about the land and its resources, rights in or over land, I think that is relevant for the purpose of our case.
For our case, it is.
For the purpose of our case, we can derive, we can take out from the interpretation what is land and its resources and land rights in or over land, I think. Because it is quite clear, concept is quite clear. Mines and minerals is different and mineral oil is different.
Is different.
And mineral oil, mines and mineral is development with, related with regulation of development of mines. And mineral oils, petroleum, diesel, whatever, inflammable, under 1953 is relatable to oil field. If we read correctly, both the acts, Oil Fields Act and Mines and Minerals Regulation and Development Act.
Yes, these are the two aspects.
Two different things. And all the dispute is regarding mineral oils, means petroleum and other thing. Not this coal or whatever,
Yes, yes.
manganese, bauxite, no.
No, we are on petroleum product.
We are only petroleum.
Yes. And so far, my lord, your lordship, the pre.
Subject to correction, I am saying
No, my lord, we are just sharing the views only. Now, so far 1948 Act, so far Mines and Mineral Act is concerned, there is a pre-constitutional act, and your lordship will find the petroleum, mineral includes petroleum.
now, have you
In the definition it is given.
Have you seen the statements and objects of Oil Fields Regulation and Development Act
Yes.
1948?
Yes.
So let us see
Yes.
that statements and objects.
Your lordship first look at. Mines and
Because
Mineral
by the
Regulation.
statement and objects,
Yes. My
it
lord,
has,
if your
it has,
lordship-
it has taken out mineral oils out of mines and minerals.
My lord, so far Mines and Mineral Regulation Development Act 1948, the pre-constitutional act, your lordship may see how it is defined. Section 3, my lord. Section 3, where relevant entries C. Minerals include natural gas and petroleum.
Hmm. Then see the definition of in the Mines and Minerals Regulation and Development Act,
I've taken to your lordship 48 Act.
right? The things have changed.
Yes, then
Before
57
creation of Nagaland,
57, my lord, that has said the petroleum is not included in the mineral.
so things have changed before creation of Nagaland.
Now, these so far 48 Act is a repeal when the saving clause is there. In 57, your lordship will find.
Kindly see 57.
Yes.
Definition clause. First, the preamble also.
Yes.
Definition,
Not be clear.
minerals,
Your Lordship may see,
minerals,
yes,
Only again.
with three.
Just one.
section 3,
AD,
small ad.
AD is one, last time I had pointed out,
Hmm,
and the other is B.
B.
B. Mineral oils means natural gas and petroleum.
We are dealing with natural gas and petroleum here.
Yes,
Correct,
yes.
ma'am. But they say minerals includes all minerals except
Except
mineral
mineral
oils.
oils.
This act goes.
Now, so
So,
far,
if we see now, if you see the Oil Fields Regulation and Development Act 1948,
Yes.
as you are harping on one
right.
particular 1948
Yes,
act.
Yes, that is also, that was saying.
That is also same, my lord.
See,
Mines means any excavation for the purpose of searching for obtaining mineral wells and
C.
three mineral wells include natural gas and petroleum.
Hmm. Now, if you see the statements and objects of the 1948 Act,
Yes.
Yes.
the first line itself, originally oil fields, mines and minerals
Yes.
were comprehensively regulated together through the Mines and Minerals Regulation and Development Act 1948.
Yes.
Subsequently, in 1947, the Mines and Minerals Regulation and Development Act 1957 was enacted for the development and regulation of mines and minerals under the control of the Union. The original Act of 1948 was also renamed as the Oil Fields Regulation and Development Act 1948. It has been renamed
Rename.
and the said Act and made applicable to mineral oils only. The said Act which provides for so and so, so and so. Then 3. It felt necessary to amend the said Act and for that purpose, so and so. So this is the 1948 Act has been renamed as Oil Fields Regulation and Development Act 1948 and made applicable to mineral oils only. And mineral oils includes petroleum and
Natural gas.
natural gas. So we are dealing with that.
Petroleum and natural gas.
Yes.
Exactly. Now, mineral.
So mines is always coal, bauxite, manganese,
Yes, sir, that is not.
iron.
Yes, yes. Your lordship is very correct.
100%.
Now, here, my lord, now your lordship, let us see what is the meaning of land.
Yes. We are dealing with land.
Here.
Yes. 75. Yes. 75 to SSC.
1975,
Yes.
the lordship may see 1975 to SCC 175.
Pardon me, please give again.
1975 to SCC
175.
175. I'll take your lordships to paragraph 44 and 45.
Paragraph.
44 and 45. Mr. Tarkunde, on behalf of the petitioner company, has urged under entry 49 of the state list in the seventh schedule to the constitution, the state legislature is empowered to enact a law relating to taxes on lands and buildings. They submitted that the state legislature has no competence under the above entry to enact a law for levying tax in respect of the area occupied by the underground supply lines. The word land, according to the learned counsel, denotes the surface of the land and not the underground strata. We are unable to accede to the above submission. Entry 49 of list 2 contemplates the levy of tax on lands and buildings or both as units. Such tax is directly imposed on lands and buildings and bears a definite relation to it. Section 129 makes provision for the levy of property tax on buildings and lands. Section 139 merely specifies the persons who would be primarily responsible for the payment of that tax. The word land includes not only the face of the earth, but everything under or over it, and has in its legal signification an indefinite extent upward and downward, giving rise to the maxim so and so, so and so. According to Broom's legal maxims, 10th edition, page so and so, not only has land in its legal significance an indefinite extent upwards, but in law it extends also downwards, so that whatever is in a direct line between the surface and the center of the earth by the common law belongs to the owner of the surface, not merely the surface, but all the land down to the center of the earth and up to the heavens. And hence the word land, which is so and so, includes not only the face of the earth, but everything under it or over it. Then para 45. By for the largest number of persons rated are as occupiers of land or houses, the word land as used in the statute must be understood in the widest possible sense. It includes not only the surface of the earth, but everything under it or over it. Then, my lord, I will take your lordship to another decision of the Constitution Bench.
NSSC. NSSC.
2004 10 SCC, page 201. No. Paragraph 39, mate. The word land, as used in entry 49 in list 2, came up for the consideration of this court in Anand Mills Company Limited versus State of Gujarat. The earlier judgment I have shown you. It was held that the word land cannot be assigned a narrow meaning so as to confine to it.
Whatever.
Mhm.
He would later be the legal person. He adjunced in a bump. That's it.
Well, I am reading paragraph 39.
Yes.
The word land as used in entry 49 in list 2.
Yes, yes, please continue.
Came up for the consideration of this court in Anand Mill Company versus State of Gujarat. It was held that the word land cannot be assigned a narrow meaning so as to confine it to surface of the earth. It includes all strata above or below. In other words, the word land includes not only the surface of the earth, but everything under or over it, and has in its legal significance an indefinite extent upward and downward, The four-judge bench upheld the validity of the law levying tax in respect of area occupied by underground lines by reference 2049, list 2, holding it to be a tax on land only. And this has been upheld by the it has been upheld by the 9 judges judgment, my lord. That also I'll take your lordships.
Paragraph 250 onward.
That's perfect. Oh. Not take a look at that. One 87.
Paragraph 275.
Only, sir, I have another one. Let's, somebody ঠিক ই বলছে।
These are looks up at
না না পাইছি তো আমার এটা পেপার উঠে গেল Two 75, your lordship, kindly see.
Yes, I have
The-
seen.
Expression land means all kinds of lands irrespective of the use which the land is put. The expression lands include not only the surface but everything under and above the surface. Now, this has been, my lord, upheld by the 9 judges bench also. Now, therefore, my lord, I will take your lordships to the next point. Whether we can say that Article 371A is an enabling provision to the state legislature to enact any law. But in regard to that, I will take your lordship to the judgment of the Apex Court, report in 2018-14 SCC, page 408. The lordship may see from para 23 onwards. I'll refer 23 to 28, then 29 to 30, 36. There are 23. The authority to make law flows not only from the express grant of power by the Constitution to a legislative body, but also by virtue of implications flowing from the context of the Constitution, is well settled by the various decisions of the Supreme Court of America in the context of American Constitution. A principle which is too well settled in all the jurisdictions where a written constitution exists. The US Supreme Court also recognized that the Congress would have the authority to legislate with reference to certain matters because of the fact such authority is inherent in the nature of the sovereignty. The doctrine of inherent powers was propounded by Justice so-and-so in the context of the role of American government in handling so-and-so. In substance, the power to make the legislation flows from various sources. Number one, express text of the Constitution. Number two, by implication from the scheme of the Constitution. My Lord, I'll press on that. By implication from the scheme of the Constitution. Now, the scheme of the Constitution is so clear, which is said when the parliamentary laws, my Lord, in regard to the land and its resources, are totally banned. In such circumstances, we cannot think that law in regard to my Lord, legislation to be made by the state legislature, if it is stopped, then the resources so far in the storage of the state, that will remain like that forever. And the earning of revenue will also totally stop. And the constitution framers never intended that sort of idea. In substance, the power to make the legislation flows from the various sources. Number one, express text of the Constitution. Number two, by implication from the scheme of the Constitution. And then as an incident sovereignty that is always there. Then paragraph 26. Lord, I will read paragraph 25 because the Lordship has referred one constitutional bench judgment. I'll take your Lordship to that also. Unlike the American Constitution, we choose to adopt a constitution which regulates and structures not only the authority of the federal government, but also the components of the federation, states, and now even the local bodies. Coming to the questions of the authority of the legislatures, federal and state, we are of the opinion that analysis adopted by the US Supreme Court is equally good for our constitution with appropriate modifications because there are areas where the two constitutions differ substantially. However, the principle that the power to legislate.
But Mr. Datta, this goes against your argument because here referring to 246, it says that the state government did not have legislative competence to make an enactment.
No, my Lord, let's see one thing, my Lord. Source of power is Article 245 and the field of legislation is 246. And my Lord, with the opening word of 371 is notwithstanding anything. That overrides, my Lord, Article 245 and 246. Therefore, my Lord, the constitutional framers, they had the idea because they were in know of the thing. There is a provision like entry 53, 54 of list 1. At the same time, entry 18 and 23 operating. Now, in a given situation, if there is inapplicability of the central law comes up, they were mindful of the situation, that situation may arise. Then, my Lord, the state legislature will have to have the power. And moment, my Lord, your
No,
Lordship,
then this is counterproductive argument. You come to paragraph 29
29 of, my Lord,
of the same judgment.
yes.
It must be remembered that this court repeatedly held that the entries in the various lists in the 7th schedule are not the sources of legislative power.
Exactly. That is, I'm also saying. Because entries in the 246 is not a power, is not a source of power, is a field of legislation. my Lord. Now that can be broadly interpreted by giving the true meaning of the constitutional amendment. That is our case. my Lord.
Source of power is Article 25, 245.
Lordship will find Article 245 is a source of power both for the Parliament as well for this, as well as by the state legislature. And nobody can tinker with that position. And 246 is the field of legislation. The field of legislation, my lord, can be broadly interpreted to give the meaning of Article 371A. Otherwise, what will happen, my lord? If we give a contrary interpretation on these, the entire provision will become negatory, and the constitutional amendment will have no value. And aims and objective, if your lordship look at the sentiment of the Naga people, they wanted independence in 1946. Now the government of India came into operation saying that let us discuss about it and find out some way and means. And therefore, my lord, they asked the Naga people convention who represented the Naga people, they've said, well, these are the formula we are giving, that is clause 7 of the 16-point agreement. My lord, then ultimately on the 9-point agreement, the government did not agree. On 16th point, they came to an agreement, and these 4 clauses, as your lordship has seen, which has been crystallized into the 371, that has come up. So therefore, these constitutional amendment has great value so far the people of Nagaland is concerned. Now, in this
Just
stage,
take a short break and come back.
well, no, wait, this one. My lord, I'll take your lordships to the point that in regard to Mines and Mineral Act 1948, then Wellfield Regulation 1948, and Mines and Mineral Act 1957. These, when this particular 13th Amendment was came into being, my lord, at that relevant time, these were already there. And the constitution framers were totally mindful of the situation. Nonetheless, they made this amendment in order to give benefit to the agreement entered into between the Naga People's Convention and the Union of India. Therefore, any treaty, whether the Nagaland is the only state possibly in the country which came into being by virtue of an agreement. Now, when it comes with the aid of an agreement, and it possibly, my lord, your lordship will not go into that, whether the agreement is valid or not, because already it has been crystallized into Article 371A, and 371A has not been questioned by anybody. The Union of India, your lordship will find in this case, they came with the request of a court to be implemented as a party. They did not come up here. When the honorable court found that they may require to certain query to be answered, that way, my lord, your lordship passed an order, they came that way. So they never, my lord, made any sort of, my lord, allegation or whatever it is, that the Article 371 is not a correct amendment, because Mr. Kohli, I feel, he argued that it interferes with the federal structure of the country, but it is not. Because when a constitutional amendment has already been made, when you are not questioning, then you cannot make such argument. And my lord, therefore, I would like to take your lordships to the decision when, my lord, you make a constitutional amendment for what purpose. My lord, I'll just take your lordship to 2 paragraphs of 1973 4 SCC 225, Keshavananda's case, my lord, is the lordship well aware about that. My lord, I will take your lordships to paragraph 634. My lord, I'll hand over my book to your lordship. I have the only book here. I'll just read slowly. my lord.
Ishananda Bharti.
Fine.
Okay.
I'll just
Just-
read the 2 paragraphs, short paragraph. my lord. My lord, it is not necessary to take your lordship to this paragraph.
Just a moment.
Paragraph number?
634 and 1555. I am referring this to paragraphs only because Mr. Kohli argued that the federal structure will be infringed by virtue of that, although he did not, my lord, challenge the constitutional validity of this amendment.
Then to 73.
It is 73, 4 SCC.
Just a moment.
Yes. Two to five.
Nineteen 73.
4 SCC, page 225.
Please give the paragraphs.
634 and 1555. One 36, 135, 135, 136.
With the regulatory. They can 15,000. And, um,
Hmm, 135, that's interpreted broadly. 135. Later entries will be interpreted broadly.
Yes, 634.
Yes,
Para 634.
634 million. Every constitution is expected to endure for a long time. Therefore, it must necessarily be elastic. It is not possible to place the society in a straitjacket. The society grows, its requirements change. The constitution and the laws may have to be changed to suit those needs. No single generation can bind the course of the generation to come. Hence, every constitution wisely drawn up provides for its own amendment. We shall separately consider the contention of Mr. So-and-so that our construction embodies certain features which are so basic that no free and civilized society can afford to discard them, and in no foreseeable future can those features become irrelevant in the country. For the present, we shall keep apart for later consideration Mr. Palkiwala contention that the parliament, which is only a constituted body, cannot damage or destroy the essential features of the constitution. Up till now, we have merely confined our attention to the question as to the scope and reach of Article 368. This court has always attached great importance to the fundamental rights guaranteed under our Constitution. It has given no less importance to some of the directive principles set out in Part 4. The directive principles embodied in Part 4 of the Constitution, or at any rate, most of them are as important as the rights of individuals. To quote, your lordship may skip all that. Then your lordship may come to paragraph 1555.
Paragraph 134.
Paragraph, my lord, 1555.
1555. Okay.
My-
Yes.
The proviso to Article 368 use the expression change, and that would indicate that the term amend really means change. The main part of Article 368 thus gave power to amend or to make changes in the Constitution. Normally, a change is made with the object of making an improvement at any rate. That is the professed object with which an amendment is sought to be made. The fact that the object may not be achieved is beside the point. Amendment contains in it an element of euphuism of conceit in the proposer, an assumption that the proposal is an improvement. Beyond this euphemistic tinge, amendment as applied to alteration of laws according to the dictionary means alter or change. Therefore, my lord, it has been made some improvement by way of constitutional amendment to give the full meaning of the agreement entered into between the Naga People Convention and the Union of India. So therefore, it's no question of, my lord, the infringement of federalism so far this constitutional amendment is concerned. And more so, my lord, when you are not challenging the very purpose of the constitutional amendment like 371A, possibly this argument ought not to have been made. Now, my lord, coming back to the judgment which I was referring to your lordship, so lord, your lordship will find in nine bench judgment, my lord, paragraph 32, the lordship has clarified the 245 is the source of power and 246 is the field of legislation. So for 245, that's a complete and absolute. My lord, I'll call upon your lordship to take paragraph 32 of the nine judges judgment. The lordship got that.
Yes.
Article 245, read with Article 246, is the source of the legislative powers of Parliament and the state legislatures. The entries in the seventh schedule delineate the subject matter over which the appropriate legislature can enact laws. The entries are legislative heads. This is what I'm, my lord, giving emphasis. The entries are legislative heads and not the source of legislative powers. The legislation could be composite in nature, drawing upon several entries in a particular list. Such a legislation is referred as ragbag legislation. Ragbag means, my lord, it's the draft entry is made composing many areas, that is called ragbag. We are not concerned with that here. Now, the source of legislation is, my lord, source of power is the Article 245. So for 246, my lord, it can be given a broader interpretation to give the full meaning of the constitutional amendment. And that is what, my lord, this judgment I have referred, their lordship has upheld that. No, no, session, no?
মোটা আগে লেখাই কন্ট্রোল যে বললো না প্রেসিডেন্টটা তোমার আগে আসবে নজর দিয়ে আমার দিয়ে একটা হবে জানবো আমিটা শেষ করে
Okay. Dole. My lord, I'll take your lordship to 2018, paragraph 26 onwards. 1814 SCC, page 408. Paragraph 20, from 24 itself. In substance, the power to make the legislation flows from various sources. Express text of the Constitution, then by implication from the scheme of the Constitution, and as an incident of sovereignty. Then 25, unlike the American Constitution, we choose to adopt a constitution which regulates and structures not only the authority of the federal government, but also the components of the federation. Coming to the questions of the authority of the legislature, federal and state, we are of the opinion that analysis adopted by the US Supreme Court is equally good for our constitution with appropriate modifications, because there are areas where the two constitutions differ substantially. However, the principle that the power to legislate under the Indian Constitution can flow from various sources as recognized by the court in Synthetic and Chemicals Limited versus State in paragraph 67. Then Article 246, one of the sources of authority to legislate under the Constitution of India, it declares that Parliament and the legislatures of the various states have the power to make laws with respect to any of the matters enumerated in each of the three lists contained in the seventh schedule. It also makes clear that the power of Parliament is exclusive with respect to list 1 and that of the state legislature with respect to list 2. List 3 indicates various fields over which both Parliament as well as the state legislature would have authority to legislate concurrently, subject, of course, to the discipline of Article 254. Apart from declaration contained in Article 246, there are various other articles of the Constitution which confer authority to legislate either on Parliament or on a state legislature, as the case may be in various circumstances. So their lordship has given some example, then even there may not be any entry, nonetheless, the law can be inferred from there. Article 3 authorizes Parliament to make a law either creating a new state or extinguishing an existing state. Such a power is exclusively conferred on Parliament. Then Article 326, while declaring a right of every citizen who is not less than 18 years of age to register as a voter at any election to the House of the People or to the Legislative Assembly of a state, authorizes the appropriate legislature to disqualify any such citizen to be a voter on any of the grounds specified under Article 326 by making a law. The authority to make such a law obviously flows directly from the text of Article 326, but not from Article 246. See also Article so and so, The articles mentioned above are only illustrative but not exhaustive in the category. It must be remembered that this court repeatedly held that the entries in the various lists of the seventh schedule are not sources of the legislative power, but are only indicative of the fields which the appropriate legislature is competent to legislate. The task of this court in identifying the scope of an entry in the list contained in the seventh schedule is not easy. While examining the scope of the entries, this court must necessarily keep in mind the scheme of the constitution relevant in the context of the entry in question. Here, my lord, this is very important for the purpose of this case. My lordship will see that what is the scheme of the constitution. The scheme of the constitution very explicit. Lord, that has said to give the sentiment of the people of the Nagaland, the agreement was entered into. There's a kind of treaty. So therefore, in order to give effect to that, my lord, the 371A was inserted. And it starts with the language, my lord, I will, at the cost of repetition, I will try to take your lordship to that. 317A, your lordship kindly see once again. So emphatic, so explicit. My lord, your lordship kindly look at 371A once again. Special provision with respect to the state of Nagaland, notwithstanding anything in this constitution, no act of parliament, your lordship kindly see, it is a constitutional restriction on the 245. No act of parliament in respect of, my lord, I am skipping Roman 1 to 3. I am on 4 because we are concerned with 4 only. No act of parliament in respect of ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. So, my lord, the State Assembly has already taken a resolution that the enactment so far 1957 that is not applicable in the state of Nagaland, and that resolution was already taken. In view of that, the Central Act has got no application at all. Therefore, my lord, this is an enabling provision which gives power to the state legislature to make a law on the subject, land and its resources. That is for that limited area, my lord, because the agreement was entered into clause 7. If your lordship look at the agreement, very emphatically say on these 4 areas we are considering, if this sort of liberty is given to us, we are ready to enter into an agreement, and the Union of India agreed to that. Now, in view of that, my lord, and it is already given to the state legislatures the power. If you want to accept the central legislation, well, it is up to you. You have to take my lord, the assembly will have to take a resolution that we accept the parliamentary legislation. In case, my lord, they do not accept that parliamentary legislation, so far the land and its resources are concerned, to that limited extent, the Parliamentary Act will have no value at all. It is not applicable at all. It is a completely done. So therefore, in that context, the constitutional framers were very much aware of that situation. In a given case, that situation if arises, there will be a necessity to make a law on that subject, and the state legislature will have the power to make their own law. Otherwise, your lordship kindly see, if the state legislature would not have any power to make any enactment, there would have been some bar on 371A. That bar is not there at all. Apart from that, there would have been some changes in the entries in view of 371A 1 to 4. There is no additional entries there because this power was ipso facto given by virtue of 371A. This is the supreme power, and the parliament cannot do anything. Once the state assembly takes a resolution that Central Act we are not accepting, that's the end of the matter. Now the source of legislation can be said that this power comes up from 371 as an enabling provision. Therefore, your lordship, initially when the order was passed My lord, better I take your lordship that order also. Because we are actually on that part of the thing only. This is an order passed by on where is that order? First order. I'm troubling your lordship to take order dated 8/10/2015 by Honorable Justice Ujjwal Bhuiya. His lordship rightly said that so far 371A is concerned, we have the full view that the Parliamentary Act may not be applicable. But so far 371, we are having some tentative view and it needs some full examination at the time of hearing. So therefore, that part of the thing your lordship will find, the order dated 8/10/2015,
What is it?
lordship got it. পুরোটা নাম বলো আপনি। পুরোটা middle থেকে দেখালে হবে।
Order dated?
8/10/2015. Lordship got it.
Yes.
Heard Mr. So-and-so.
Is it correct? Just one. What is it correct?
Clean has been expanded.
Yes.
Para 4 I am reading, my lord, second para. This is a public interest litigation. My lord, initially it was filed by Lotha Ho, my lord, a local body challenging the constitutional validity of the regulation. After that, my lord, they withdrew it. Thereafter, my lord, this honorable court made a suo motu matter, and that it is on that premise it is here. This is a public interest litigation filed by the Lotha Ho, its chairman and general secretary, claiming to represent the interest of the Lotho tribe predominantly residing in the district of Hoka. By filing this PL, constitutional validity of Nagaland Petroleum and Natural Gas Regulation 2012 and Nagaland Petroleum and Natural Gas Rules 2012 have been challenged. Further challenge has been made to the impugned permit dated so and so issued in favor of respondent number 7 for mixed operations, that is exploration, production, extraction, and refining bottling of petroleum and natural gas in respect of Oka district appearing at so and so. And senior counsel for the petitioner submits that state of Nagaland had enacted the Nagaland Ownership and Transfer of Land and its Resources Act 1990, which governs prospecting or mining operation in the state of Nagaland, license or lease granted by the state. This is the substantive enactment governing exploration of crude oil and allied activities in the state of Nagaland. It submits that an amendment was brought into the aforesaid act by the Legislative Assembly of Nagaland in the year 1995. But the Amendment Act is yet to receive the assent of the President, notwithstanding the availability of the aforesaid Act of 1990, which is governing the field. State legislature has enacted the two impugned Nagaland Petroleum and Natural Gas Regulation 2012 and Petroleum and Natural Gas Rules 2012, which provides for exploration of crude oil and allied activities, referring to the various constitutional provisions relating to conduct of legislative business. And the senior counsel for the petitioner submits that the impugned regulation and rules of 2012 do not meet the constitutional requirements. Further contention is that when the 1990 Act is occupying the field governing the particular subject, it was not open to the Nagaland Legislative Assembly to have enacted the impugned regulation and rules of 2012.
Has been enacted by the Nagaland legislature.
Further contention of the learned senior counsel for the petitioner is that the impugned regulation and rules under which the permit has been issued to respondent number 7 do not provide for acquisition and acquisition of land of the affected and landholders for the purpose of drilling and other activities relating to well exploration, thereby seriously jeopardize their valuable rights over the land and property, inasmuch as the provision that have been enacted only providing for sharing of revenue and discovery of crude well in a particular ratio. In the event crude well is not discovered, state has not made any provision for providing compensation to the landowners and to other affected persons for the use of the land. He is also referred to the provision Article 371 of the Constitution in support of his contention that, considering the special status of the state of Nagaland within the Union of India, adequate safeguards are required to be adopted by the state while allowing extraction of mineral resources of the state so as to protect the interest of the indigenous tribal of the state. Referring to the antecedents of respondent number 7, the senior counsel for the petitioner submit that respondent number 7 has been incorporated only on so and has already suffered adverse orders at the hands of Securities and Exchange Board of India. Therefore, awarding a permit for exploration crude well to such a party is not the public interest. London Additional Advocate General Nagaland, on the other hand, submits the impugned regulation and rules have been framed to further the interest of the state and to augment revenue mobilization, which has assumed emergent proportion. He submits that though issues raised by the petitioners may require further examination of the court, keeping in view the commercial interest as well as the revenue interest of the state, court may pass any interim order at this stage. So-and-so counsel appearing for the respondent of 7 at the outset has questions the bona fide and locus standi of the petitioner to institute this PIL. He is referred to various decisions of the appeals court to contend that in matters relating to commercial transaction, court should be circumspect while entertaining such PIL. To further submit, the respondent of 7 has already invested substantial amount of money for mobilization of man and materials to start well exploration work in terms of the permit granted. Further, at this stage, restraining respondent number 7 from carrying out its lawful activities in terms of the permit granted by the state would not be justified. So-and-so also submits that the affected landowners have not been made party in the PIL who are necessary parties to the lease. In the absence of necessary parties, no proper and fair adjudication of the dispute can take place. As a matter of fact, the landowners are not opposed to well exploration by respondent number 7, and in this regard have entered into agreements with respondent number 7. Therefore, on this count also PIL should be dismissed. In his reply, Mr. So-and-so petitioner has referred to various documents placed on record to contend that prior to institution of the PIL, there were series of discussion at various levels authorizing the Lotha Hoho to file PIL. Lotha Hoho is the apex body of the Lotha tribals. Earlier, the Kohima Union of Lotha Hoho had filed a writ petition on the same subject, but the same was withdrawn with liberty granted by the court to file a fresh writ petition. Consequently, the present PIL has been filed. It submits that when, now your lordship may see the next para, issues raised in this PIL may require further deliberation of the court. In view of the above, let this PIL be admitted. Then respondent number so-and-so are represented by your lordship may skip this para. Then Article 246 of the Constitution of India deals with subject matters of laws to be made by Parliament and by the legislature of states. In terms of Article 246 7 schedule, to the Constitution envisages 3 lists enumerating different subjects covered by the 3 lists. List 1 is the Union list, List 2 is the state list, and List 3 is the concurrent list. Subjects enumerated under List 1 are within the exclusive domain and legislative competence of the Union Parliament. Entry 53 of List 1 deals with regulation and development of oil fields and mineral well resources, petroleum and petroleum products, other liquid substances declared by Parliament by law to be dangerously inflammable. Thus, prima facie aware of the view that exploration of oil and natural gas is a subject which is covered by Entry 53 of Union List, which means It is the Parliament which has the legislative competence to enact laws on this subject. Article 371A of the Constitution deals with special provision with respect to the state of Nagaland. Clause 1A of Article 371A provides that no act of Parliament in respect of religious or social practices of the Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decision to Naga customary law, ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. A careful reading of the aforesaid provision would show that no central legislation in respect of the aforesaid subjects shall apply to the state of Nagaland unless the same is adopted and made applicable to the state of Nagaland by the Legislative Assembly of Nagaland. This constitutional provision, which has been heavily relied upon by Mr. So-and-so, in our opinion, is meant to ensure protection of various aspects of Naga way of life and social practices, as well as ownership and transfer of yes. It does not, in our tentative view, confer further competence on the Legislative Assembly of Nagaland. It does not, in our tentative view, confer further competence on the Legislative Assembly of Nagaland to legislate on a subject which is within the exclusive domain of Indian Parliament. This is an aspect which may require further deliberation of the court. Now, that was a tentative view of the Honorable Judge. Now, Your Lordship, the reading of Article 371 gives a very clear picture that no act of Parliament, my lord, is a restrictive way. These are four, Roman 1 to 4. We were concerned with 4 only. Now, so far, these subjects are concerned, and so far 4 is concerned specifically, which is in regard to land and its resources. Any parliamentary act, including 1957 Act, if it is not, my lord, the state assembly, if they do not take any resolution for the application of those central acts relating to land and its resources, those central act is totally inapplicable. So far the state of Nagaland is concerned. Now, Honorable Judge put a view there within the exclusive domain of Indian Parliament is not correct in the sense because the state assembly has taken a resolution that central act has been barred. Once central act has been barred, my lord, which is within the exclusive domain of Indian Parliament, it goes away. Because it is not in the domain of Parliament, then your lordship will see whether there is any corresponding entry in order to, my lord, frame any law in the subject land and its resources. And your lordship will find entry 18, entry 23. Entry 18 is a free entry, and your lordship has seen land includes everything above and beneath the earth. Okay. Now, my lord, your lordship may just for a while see entry 18 and 23 once again of the state list.
We'll have to continue tomorrow.
My lord.
On the last order, the presence will be recorded, huh? As per last order, then say the submissions of the learned advocate general is concluded. So the submissions of Mr. S. Datta and Senior Counsel appearing for respondent number 7, along with Mr. A. Dasgupta and Senior Counsel, remains inconclusive. List on tomorrow, it's 28. And you also record the presence of the standing counsel for the High Court. It's there in the last order. And Mr. C.T. Javed, amicus curiae. The presence of the standing counsel for High Court will be through video conferencing. Huh?
Yes, Lord.
In last order, and record it.
I'll be
Yes,
giving
last-
all my decisions pertaining to all the subjects separately. I didn't want to read it out.
Announcement of judgment public order, item 10, WPC 7685/19.
The case is remanded back to the tribunal for fresh adjudication.
His Lordship, I'd like to mention item number 4, Lordship. My senator was feeling not well, so he left the court early, Lordship. Pass it.
All other matters will be adjourned. We are taking up HPSC matters. So by default, it will be adjourned.
Yeah, please.
Yes, Mr. Rajkumar.
Item number 1 of the daily list.
Yes.
Lordship, the IO was called in, the CD was called. Can you?
CD has come, but there was some confusion. Lordship has said that let the IO should assist us. He has come, Lord, I have got the information from him. I have the case date. Lordship, a fixed date.
Can it be on 10th, your Lordship? 10th of February.
10th. Yes, 10th can come, but
that-
accommodated.
I have a small submission here. But the case diary is with us. We have called for the case diary. The progress is till the month February 25. The other some progress is there, but he has kept the other documents separately, not in this case diary. So if the case diary can be given to him, so that he will update and give me.
Return it back to you.
Yes.
How this can be done?
So I'm handing over the CD to him, and he will incorporate whatever in the meantime he has done, and he will
Perfect. Okay.
on before the next day I'll get it.
Okay.
Lord.
Mr. V. Rajkumar, learned counsel for the petitioner is present. Mr. D. Nath, learned senior government advocate, has submitted that he has called and interacted with the IO of which case? IO of
This is Maibong PS.
Maibang PS case number 2 of 18 and Maibang PS case number,
Just a moment, slow. She'll write it down.
Maibang PS case number 2/18. And second is Maibang PS case number 6/18.
18.
2 cases.
Stop. It is further submitted that he has the case diary for production before the court. Mr. We also submits that in the meantime, there is some progress in the investigation and therefore he prays for liberty to return the case diary to the IO for updation and for production on the next date of listing. Mr. Prayer is allowed. Let the case diary be returned back with a direction to the IO to produce the case diary positively on 10/6/2025. Next list on 10/6/2025.
Obliged.
Yes, please.
My lord, the last,
Lordship, if
Yes.
Lordship would permit me for a minute before Mr. Nath starts.
Yes, yes.
Just one thing, Lordship. I'm in a very weak signal zone, so I'm putting my video off. That's all I just thought, because I'm with difficulty actually logged in. That's all I just wanted to know. Let Lordship.
Please repeat again. I did not get it, Mr. Kohli.
My signal is weak, Lordship, so I'm keeping the video off. That's all I'm saying, Lordship.
Okay. I understand. Okay. Okay, you may do so.
there is, I think, because I tried,
Grateful, Lordship.
the lordship can hear it?
Yes.
Line again too. Because I tried to look over the matter yesterday, day before yesterday, I think, but I couldn't get it because there is no live streaming, I think.
I don't know.
I know I don't know, because I tried to look after, because I couldn't get it, but whatever may be the reason, my lord. Yeah, I'll just start, my lord, where Mr. DK Mishra Rane Senior Counsel has ended, because that will be, your lordship will get a flow out of it, my lord. My lord, regarding APS service, my lord. Earlier case, what was there, I will just continue, but major, I have argued that case. If your lordship kind enough to take Writ Appeal 333 of 2020.
Item number?
Item number 49. 49. 333. Oh. Because I think our senior Mr. DK Mishra have argued this matter. He had made reference to Writ Appeal 333 of 2021.
sir.
333 was not referred by him.
No. My lord, he referred. No, on notification was referred. OM. OM was referred.
Okay. Which page was that OM?
My lord will kindly look into. First see at page 69, which I think, this was referred by senior counsel Mr. DK Mishra at page 69. If your lordship looks at page 69.
Order was impugned by separate petition.
Because here, my lord, the impugned order of extension was challenged, put to challenge by way of a writ petition. Separate writ petition. So if your lordship now looks at page 69 and page 91, yes, sorry, page 94,
Yes.
is the extension of provision of say Kavita Das. Lordship kindly see the last 3 lines, is pleased to extend the period of probation of Srimati Kavita Das, APS, for another 2 years. Dated is, it is an SMEs. Kindly see, my lord. Dated in SMEs. If your lordship kindly see the signature, Additional Secretary Government of Assam, it is in SMEs at page 94. That I have not come across. And SME is a signature, all in English except that is in SMEs. See 34, 30, 30, 12, 30, 12, no? 30, 12. 30, 12. My Lord, Honorable Justice Malasi Nandi
Yes,
has
I
got
got
it.
it. I got it.
Yes, this is 30, 12 in SMEs. Kindly see.
Yes.
Yes. Now if you see at page 69, why this was referred 69, kindly see, my lord, this is 15th of September 2017. These are the posting of different officers
Yes.
who were earlier on probation, but our argument, and we will show that their services had been confirmed by this order. If you see at page 73, now he referred, but I just want to read this C73. C73, mile.
Yes, yes, we have it.
Yes, see the last paragraph.
Yes.
The above posting of APS junior grade so and so 2015 batch have completed probationary period of 2 years and are exempted from mandatory posting in the battalion for period of 4 months as per OM dated 38/2004, as the services are urgently required to be in the field and a special agency border vigilance due to shortage of officer. Now, my lord, there was a discharge order which was issued in favor of the petitioners, all these petitioners, and that was put to challenge. Discharge order was put to challenge, and they have invoked the service rule. They invoked the service rule and they said, we are discharging you from service on the basis of a police report. Now, while this was put to challenge, our case, which is projected before the learned single judge, is that, look here, this is an OM. By this OM, we have completed notification, which is issued by the order by the governor. And by this notification, our services had been confirmed. Right, my lord, at page 73. Now, when this was presented, placed before the learned single judge, they filed an affidavit before this honorable court. And they said, second additional affidavit they filed and they said, no, your services already has been extended. And this is the 94 which has been extended. Now, this was put to challenge by a separate set of writ petition. Before. That's 7122 of 2020. 2019. 7122 of 2019. Because this is an order which they brought after we filed the writ petition. They brought it by an additional affidavit. Second additional affidavit, they brought it. Now the position is now, your lordship. What we argued before the court was that this notification, at least they should have published one, or they should have communicated to us, which has not been done in the instant case. Now let us, for an argument's sake, my lord, let us say that this notification is true and correct.
Which
Let us-
notification?
This notification of December 2017, which is in SME at 94, the order impugned, 94. Well, let us.
Yes.
Now, while deliberating before the earlier bench, we said before the court that this is a manufactured document. How can you do it? These are all afterthought and these are manufactured by you. Then the court said that whether this notification, it is gazette notification is there or not. But anyhow, they could not produce the gazette notification. Now, for an argument's sake, let us say this notification is true and correct. Let us say, because now question will come, my lord, because we are from a trial court, we'll always say that if this is a disputed question of facts, you are saying that this is there, this is manufactured, and they are saying it is not manufactured. This being disputed question of fact, how your lordship can look into it if it is a disputed question of fact? To decide this case. Now, I look in this way, my lord. Now, I'll give an answer to it, that this notification,
Well, this, I think Mr. Mishra argued that none of the authorities got it.
no, that is one. This is one. In addition to that,
Question was asked.
but this question was asked by your lordship and he has given answer that it was none of the authorities, like I am a APS, my authority being an SP, so controlling authority, DGP is there. It should be within their knowledge that this notification be issued, but it was not communicated because there are letters, RTI was made. I think that has already been argued. That's why I don't want to trouble the court. I think your lordship that is argued. I don't want to waste any argument. In addition, which is most important in this case, is that whether, my lord, at page 94, even if it is not a gazette notification, whether it has to be communicated to the petitioners or not. That's the issue before this court.
It can be given effective
Or it can be given effect to it. My lord will kindly see whether it can be given effect to it.
without deciding whether it is genuine or fake.
Yes.
Whether it is a fake or whether it is genuine, please don't decide without deciding that. Whether this particular notification should have been communicated to the petition. My answer will be yes, it should have been communicated.
Before that going to the.
Now, before that, which is most important is that I'll give an answer and I'll show a judgment of the Supreme Court. My lord, before that, if your lordship looks at page 69 once again, I'll trouble your lordship with 69 and at page 73. Kindly see 73.
Yes.
And kindly see the last. The above posting of APS junior grade so and so have completed provisionary period of 2 years and are exempted from mandatory posting in the battalion for a period of 4 months as per OM dated 38/2004 as their service urgently required in the field specialized agency. So what is that OM of 38/2004? I think lordship really wanted to know what is that notification. Now I'll just pass on what is the notification. Kindly look at the notification bar. OM, Office Memorandum. 30 August 2004. Lordship got it?
Yes.
With the note I have given.
With the note I have given.
Yes.
Yes. In partial modification of the department's OM number dated 25/9/2003, the period of compulsory posting in respect of newly recruited Assam Police Service junior grade officer in Armed Police Battalion. Now kindly mark, after completion of prescribed provision period of 2 years is reduced from 1 year to 4 months with immediate effect.
This can only apply to confirm the.
Now only this OM, my submission will be, this OM only will be applied to a confirmed employee.
It cannot apply to.
So it is not, they say this will apply to a provision.
It cannot apply.
Yes.
The OM reads after completion of provision.
My lord will kindly read the wording of this office memorandum. After in the period of compulsory posting in respect of newly recruited after completion of prescribed provision period. Lordship got it, my lord? After completion of prescribed provision period. So this will not apply to provision period. This is only notification applied to a confirmed employee. After completion of the provision period.
They could not have dispensed with my battalion.
Now, my lord, dispensing Now kindly see here. As the services, now if you see at 73,
Yes.
now if you see 73, now my lord, what happened, my lord? After you complete 2 years of provision period, now mandatorily you are appointed in the as a posting, first posting in the battalion. Charge posting, my lord. But this was exempted. Kindly see, my lord. It was exempted. N are exempted. If you see at 73,
Yes.
N are exempted from mandatory period in the battalion for a period of 4 months as per. So it was initially 1 year, which was reduced to 4 months by this office memorandum.
This OM is only applicable to confirm.
Yes.
after completion of provision.
And are urgently required to the field in the special agency and due to shortage of officers. So there was shortage of officers. They said that we are exempting that posting at battalion. So you are required in some other field because there is a shortage of staff. That's my argument, my lord. This will not apply to a provisionary provision period. It is only in respect of a confirmed after completion of the provision period.
for this OM.
And this OM is 30th of August 2004. So I think this was not showed before this court.
Yes.
I am clear, my lord, with this, my lord.
Yes.
Now I again go back to page 91 to demonstrate before this court. 92, no, 94 to demonstrate before the court.
Yes.
Judgment of court court on Four argument for দিলে বাকি আমি ডিসেল জাজমেন্ট potential করে দিই এবারে দেখা যাবে আমাকে ওটা দেখা যাবে কমিউনিকেট করছি তাহলে যে বিজে অথরিটি অফ পিআর
Now,
একটু চাই দিব এই জাজমেন্ট এটা পারে
now, my lord will see 94. This is the notification which was issued by filing an additional affidavit before the court when we said that our services had been confirmed. After completion of my provision period, they brought this notice. Now we said this notification, what my learned friend D.K. Mishra has argued, I also endorsed to that it should have been communicated to my officer, superior officer, which was not communicated. One. Now, in addition to that, my argument is that not only gazette, it should have been communicated to the officer concerned, to the petitioner concerned, which has not been done in this case. Then this notification will not have any effect whatsoever. So this notification will be treated as null and void, non-est in the eye of law. And I will show a judgment before this honorable court. There are judgments of the Supreme Court in this context.
circumstances in handover
Now thereafter, I'll show this. What is the attending circumstances, my lord, which your lordship can look into it as a confirmed employee
to derive satisfaction.
to derive satisfaction. Kindly see at page 95. See 95. No, sorry. No,
RTI already
No,
decided this.
RTI already have shown. I will not trouble that.
Yeah, okay. It will do.
Yes. Kindly see at 74. See 74. These are the attending circumstances to show that I completed provision period. I am a confirmed employee. What is the attending circumstances? See at page.
Sir, dated 15 September.
If your
69.
lordship at page 69 is 15 September 2017. See that, my lord. Posting. 15 September 2017 at page 69.
Mark the date.
Your lordship will please mark the date. 15 September 17 at page 69.
Yes.
And please turn to page 74. Immediately,
2 days after,
2 days thereafter,
17 days.
17/10/2017.
Yes.
Now see, with reference to this rule 145 of the Assam Financial Rule 1, undersigned have the honor to report that I have this 17 October 2007 handed over, received charge of Deputy Superintendent of Police, bracket kindly see provisionary, Lordship got it, at so and so, by notification dated 15/9/2017. This is my lord, attending circumstances I am showing it.
On the same day.
On the same date, 17/10. And on the same date, see at 75, see 75 on the same date,
I have taken over.
I have
charge
taken
as
over
confirmed.
as a confirmed employee. See 17/10/2017.
Page
With
75.
reference page 75, with reference to rule 145 of the Assam Financial Rule, I undersigned have the honor to report that I have this 17 October handed over received charge of the Deputy Superintendent at 19 AP so and so by government notification dated 15/9/2017.
In terms of
So,
notification,
so,
same day,
so on the same date, in terms of the notification,
as probationer I handed over.
now as a provision I have handed over, then as a confirmed employee I have taken over.
These are the attending circumstances.
So am I clear to your lordship on these two documents?
And this is reference to 15/9.
And C 75, reference is 15/9/2017. 79, page 75.
Yes.
And I don't I want to trouble your lordship because all this was not communicated to higher up to my superior, to my the SP, DGP. That's I don't want to argue because that was argued by.
Already seen.
Already your lordship has looked into it.
Originally called the hello.
If your lordship want to look it, that is a different thing, I think.
No, I think.
I don't want.
Absolutely covered.
That's why I just noted down. I asked them to note down which are the points which I want to cover up. I don't want to repeat.
If it is not notified in the gazette, what will be the impact?
Now, my lord, I think what my learned friend is saying, a question was asked, if I am not wrong, before my senior colleague, Mr. D.K. Mishra, that what will be the effect if it is not gazette notified? What will be the effect of that extension of provision for 2 years if it is not gazette notified? If it is not notified in gazette. Now, my lord, I'll give an answer to it. I don't know what is the answer that was given and that was asked by the court. That's what I came to know. But I got an answer to it. I got an answer and I will straight away answer to that which the apex court has decided that issue. That's a constitutional bench judgment. 1966 Supreme Court 1313. AIR 1966 Supreme Court 1313. What you got it? I hope so. I am not repeating what earlier my colleagues argued the matter before this court.
Yes. Yeah,
Well,
I think which matter.
uh,
66.
66.
Yes.
My lord, please turn to paragraph 11. Lordship got it?
Yes.
Turn to paragraph 11. I think Honorable Justice
Yes.
Malasi Nandi has got it. Yes. If you turn to para 11, just leave first, second, third, fourth, fifth, sixth, seventh line. Leave 7 line of paragraph 11 from the top and start with it is. Like got it?
Yes.
It is plain that the mere passing of an order of dismissal, it is an our case is an extension, would not be effective unless it is published and communicated to the officer concerned. If the appointing authority passed an order of dismissal but does not communicate it to the officer concerned, theoretically it is possible that unlike in the case of judicial order pronounced in court, the authority may change its mind and decide to modify its order. It may be that in some cases, the authority may feel that the end of justice would be met by demoting the officer concerned rather than dismissing him. an order of dismissal passed by the appropriate authority and kept with itself cannot be said to take effect unless the officer concerned knows about the said order and it is otherwise communicated to all the parties concerned. If it is held that the mere passing of the order of dismissal has the effect of terminating the services of the officer concerned, various complications may arise. If before receiving the order of dismissal, the officer has exercised his power and jurisdiction to take decision or do acts within his authority and power, would those acts and decisions be rendered invalid after it is known that an order of dismissal has already been passed against him? Would the officer concerned be entitled to his salary for a period between the date when the order was passed and the date which was communicated to him? These and other complications would inevitably arise if it is held that the order of dismissal takes effect as soon as it is passed, though it may be communicated to officer concerned several days thereafter. Now, please leave 1, 2, 3 thereafter. We are therefore, kindly see, we are therefore reluctant to hold order of dismissal passed by an appropriate authority and kept on his file without communicating to the officer concerned or otherwise publishing it will take effect. Now, my lord will kindly see I am just and repeating, my lord, kept on his file without communicating to the officer concerned or otherwise publishing. Lordship got it? Or otherwise publishing, it will take effect as from the date on which the order is actually written out by the said authority. Such an order can only be effective after it is communicated to the officer concerned or is otherwise published. So meaning, my lord, thereby, one, either you notify in the gazette or it has to be communicated to the officer concerned. And if you don't do it, these two conditions, my lord, then this order becomes a nullity in the eye of law. It cannot be given effect to it.
Without deciding whether it is fake or not.
Yes. My lord, I am not saying that this is, I have raised, of course, that this is an afterthought. These are manufactured document. These are all fake. Only for the purpose of making a case, you brought it subsequently. Now let us for a moment say that these are true and correct. Then what is the effect of this notification? Now, if your lordship kindly skip this one after that, 1, 2, 3, 4, in our opinion, kindly see that same judgment. In our opinion, same paragraph. In our opinion, therefore, the High Court was plainly right in holding order of dismissal passed against the respondent could not be said to have taken effect until the respondent came to know about it on 28th of May 1951. So this order impugn, my lord, whereby they have extended my services cannot be given effect to. And my notification of 15/9/2017 that stands. That stands, meaning thereby my service provision period is completed and I am a confirmed employee. And attending circumstances to that is the two document.
Is in my favor.
In my favor.
None of the authorities are there.
This is over. This is done. Now, my lord, next another judgment. Right. 1994 SCC, page 178. Please mark para 14, my lord. This is para 14.
Yes.
The vital difference between an act of a legislature and a subordinate legislation was earlier notified in so and so. The act of legislature are passed by accredited representative of the people, who in theory can be trusted to see that their constituents know what has been done. And this is done only after debates that take place which are open to the public. The matter receives wide publicity through the media, but the case is different with the delegated legislation. And if you may add, also in case of orders passed by the authorities, like that in the present appeal before us, The mode of publication can vary, but there must be reasonable publication of some sort. Now in Fatima Haji Ali, now kindly see a reference may also be made in so and so, quoted, quote and unquote, see, in that judgment, the decision that the power has to be exercised should be notified in the usual manner in which such decisions are made known to the public. My lord, one last judgment also. Your lordship will just mark it, my lord. Because time is very short, I'll just not read. 2012, 6 SSC, page 384. Your lordship, this is on the same line. Your lordship can mark paragraph 30. 30 to 34. 30 to 34. On the same line. 30 to 34. I'll just place one paragraph, paragraph 33, but your lordship will mark paragraph 30 to 34. 30 to 34. Now I'll read one paragraph, 33. 33 paragraph.
Yes.
The aforesaid observation made it clear that an order passed by an authority cannot be said to take effect unless the same is communicated to the party affected. The order passed by a competent authority or by an appropriate authority and kept with itself could be changed, modified, and cancelled, and thus deducing such an order of characteristics of a final order. Such an uncommunicated order can neither create any right in favor of a party nor take away the rights of any affected party till it is communicated. I think these three judgments are where I thought that I'll give an answer to it. Because that a query was put forward by the court and I have asked my learned friend, I could not be present. With your lordship permission, I said I'll argue today. But it's good that I am arguing today because whatever was left, it's very lighter vein. Well, last batsman is the always best batsman. I thought second, third, because you will know what the court is asking actually. And what is the reply of my learned friend in the case? Now I will be fast, a bit of fast. Summarize my submission on this. Kindly take the note, my lord. 333. And who are the parties I am appearing, my lord? In that note, I have made it, my lord. Kindly see. 333, lordship got it? 221.
Yes.
Kindly see the name. Appellant number 5 is Dilip Kolita. Appellant number 7 is Kaushik Kolita. Appellant number 8 is Kavita Das. These three I am representing, my lord. 333. In writ appeal, 333 of 2021. Now kindly see the notes, my lord. Because then it will be easier. I'll just read this. Very short. A. Appellant and APS officer appointed by Governor of Assam was subject to an order purportedly passed in the name of the governor, extending the provision period by an additional 2 years after about 5 months from the date of completion of initial period of 2 years. B. The said order was neither published in the official gazette nor communicated to the concerned department, including the officer of the Director General of Police under whose administrative control the petitioner serves. That is why I have shown that to connect it. C. The order of extension provision was never communicated to the appellant. D. Appellant service was confirmed by notification dated 15/9/2017, which your lordship has looked into it, page 69 to 73, issued in the name of governor, and only after such confirmation of service the operation of OM dated 30/9/2004 was dispensed with, thereby treating the appellant as a permanent employee. E, the name of the appellant was put in gradation list, which also shows service of the appellant was confirmed, as probationers are not included in the gradation list before confirmation into service. F, appellant has received the second increment during the service, which is applicable only after confirmation, as same as a financial implication of the state exchequer. G, other attending circumstances presented through official document annexed in the appeal warrant declaration by Honorable Court, appellant was a permanent member at time of his discharge, which your lordship 74-75 page, attending circumstances, and other RTI documents. H, appellant challenged the validity of the state order under jurisdiction of his court containing legally ineffective, void, and violative of principle of natural justice, procedure fairness due to non-publication in the official gazette, and non-communication to respective concerned department, exercising control over the service of the appellant. It will be lax, your lordship will, lax procedural, your lordship will kindly mark this lax.
It's written.
Somewhere we may miss that.
It is already handed.
Yes, lax. Ground of challenge, my lord. First ground, non-communication of the order of excess affecting the service condition appellant renders the order non-est. This point I will not read this, my lord. Already I have argued this point. Second, non-communication to the concerned department violates due process. Please turn to next, my lord. 3, violation of natural justice and right to fair treatment. 4, non-compliance with statutory framework. 5, practical implication of non-communication. Kindly read this, my lord. Non-communication of the order to DGP's office and other concerned department creates practical impediment to his implementation. DGP as a head of Assam Police is responsible for overseeing the appellant's service condition, including provision. Without formal communication, the order lacks operational legitimacy and cannot be enforced. This also creates uncertainty in the appellant's service status, affecting our rights to confirmation, promotion, or other benefit which has caused prejudice to the appellant. Such non-communication of the order casts a cloud on the various work undertaken by the appellant in the capacity of a permanent employee. Now 6, the state is stopped to treat the appellant's provisioner by conduct. Now 6, my lord. Once the department issued a notification declaring that the appellant has completed the provision period, same department cannot be permitted to overturn their own decision, defend their action of discharging the appellant as provisional. Police department has utilized the services of the appellant under various capacity while treating the appellant as a permanent member of the cadre. The appellant was entrusted with the responsibility of permanent officer performing various tasks, including holding of department proceeding in respect of other junior grade employees which are otherwise not allotted to the provisioner. Appellant, being a member of disciplined force, was allowed to wear insignia of 3 stars in the uniform instead of 1 star, which is granted to a provisioner. So once the period was completed, my lord, as a confirmed employee, I was given all the necessary like treatment as a confirmed employee, whereby, my lord, I was DP also I was drawing. Now 1 star, a provisioner cannot wear it. Only a confirmed employee you can wear a 3 star. That was also given to me. That's very, very important, my lord.
Is this a part of pleading that 3 star?
3 star. This is not. This
Okay.
3 star was not a part of pleading. And all these 3 judgments, all 3 judgments I have cited, my lord. All 3 judgments. If your lordship kindly see, President relied upon 1, 2, 3 I have cited. 4 is the Maneka Gandhi case. Paragraph 10. I don't want procedural fairness. Yes, lordship knows it. Yes. This is done, my lord. Now, very interesting, I found it. I don't know, my lord. I'll place it because we got an RTI. Because I'll connect to it is very important. I realize why the government is saying that no, the court has asked that to the records of the file you can inspect. They said no, at this stage I will not allow to inspect it. There is an order. 8 to 9, 8 to 9.
To our single bench, this file noting has been taken.
My lord, see this writ petition 4198 of 2019.
Last date of proceedings before the.
This is the
Before the learned single judge.
my lord, this is what I told your lordship that I was not before the learned single judge. But my learned friend was there before the learned single judge, and on last day of the proceeding, this order was passed. Kindly see 22/1/2020. Now I just read this. Now kindly see the last next page.
Please communicate this to Mr. Kohli also.
Yes, I'll communicate. I am out.
No, he knows. 18th noted.
In fairness, he has sent me the earlier documents and I'm thankful to him. This also, one document I have got. 20-page note. It's a 20-page note.
I have sent to my learned friend. I'll send
One 20-page note.
I'll send to you. Don't worry.
Thank you, Dada.
Thank you. Now, my lord will kindly see case records. Lord, got it? Relating to a decision-making process contained in file number 1, 2, 3. Your lordship got it?
Last page. paragraph of-
Last page. If your lordship sees file number 1, 2, 3, 4, 5. Now, please see file number 6, serial number 6. FTX 115 of 2017.
Yes.
Now, please, this your lordship will show your lordship FTX 2117. But before that, I'll just read one, the division bench of this proceeding, what it said. I'll not trouble. 29/9/2023 order.
It was there, it was file noting this. It was खाली
I'll just,
No, it was order there. It was file noting to this. It was खाली
yes, I'll just read this, my lord. Learned counsel, and this is a file, I will show it. Or these orders, I'll just read this order. Learned counsel repent the appellant requested permission to inspect the files. Order of 29/9. This is not before this court. Earlier I have given us Earlier I have given this order of 29/9/2023.
These proceedings.
It will proceeding, this proceeding only, 29/9/2023. Is there, well, I got it.
Okay.
I don't have to trouble. See this order, mine, and see the last page. Last page. Mr. D. Nath, Lane Senior Government Advocate, Assam, also got it,
Yes.
has presented the original files pertaining to discharge of the appellant for perusal of the court. Learned counsel representing the appellant requested permission to inspect the file, but Mr. Nath, on instruction, stated that inspection of the file should not be allowed at this stage. I remember very well.
There was a liberty given to obtain copies.
Yes,
Those are obtained.
Yes, that is.
that is RTI, we obtained.
But some of them were refused.
But some of the candidates,
Refused.
when they file, some even refuse. But some of the candidates, they got it.
One.
Only one candidate, they have got it.
Rest they say it is sub judice, it is public interest, we will not do. This is the file noting. This file the court has already looked into. Learned single judges, actually.
This noting, your lordship has seen 1, 2, 3, 4, 6, what I said.
Before
FX
the learned single judge.
before the learned single judge, FTX 115 of 2017, which is noted by the learned single judge.
And
Yes.
so division bench also.
Division bench also has the original record was produced and it was looked by division bench. But court said, why you are not allowing? They said, at this stage we are not allowing to inspect it.
Okay.
Could not file it because I got.
Now belated, I got this. I could not file it. Belated, I got this.
From some.
This
from another-
RTI.
From another candidate.
From
Okay.
another candidate,
It's not part of the record.
Yes.
which is not a part of the record, but it is in the file. But this is not through an RTI. Now, very interesting, my lord. If your lordship turn this RTI, see from page
One internal page.
19 of it. Page 1. See page 1,
The second page in the
second page. Page 1. Lordship got it?
continuous notes.
Continuous note sheet.
Yes.
After that, continuous note sheet, please turn. This will be page 2. Next page 2. They have marked serially. Lordship got it? Page
Yes.
2. And see FTX 115 on the top, on the right hand side, left hand side.
Yes.
115 of 2017.
Yes.
Which has been indicated by the Honorable Single Judge.
Yes.
Now, see on the all the column, your lordship will see the date. I have checked all the dates and see the serial number. 4C, right hand side on the top, serial number 5, 122/C. Lordship got it?
Yes.
And please go down the right hand side. The dates 2021-2018. Now, all the dates. Kindly, if you see at 3, it is FTX 115-2000. All the dates, serial number, everything is there. Now, if you see at page 19, see at page 19 now. Suddenly,
Once I can take you to.
I don't want to trouble with all the dates. It will take a lot of time, but your lordship will look into these dates. All the dates I have checked personally. If your lordship want, because I have to show that one date, how it has come, I don't know, in what manner. All this was handwritten. My lord will kindly see. From page 2, if you see page 2, all it was handwritten. See, my lord, 5, 6, 7, up to page 18. See, up to page 18.
Yes.
All handwritten. Lordship got it?
Yes.
Suddenly on page 19, it is typed. Now see why. All this is handwritten. And see 19 now.
Yes.
Now, if you see at page 19 on the top, serial number 285/C. Lordship got it? FTS 115/2017. That's the file 285. This order has, your lordship has read the order 22/1/2020 in writ petition. Now you go, this is the commissioner secretary. Going below, note. If you see, after rule 19, see, further all the, lordship got it, further?
Yes.
Further, all officers who were appointed on 2015, their provision period were extended for another 2 years. White notification is serial number 287-288C. Where is that? That on the day 285, this was not bond. How you got that 287-288? It should be earlier to that.
When you referring to.
When you are
earlier
referring
incident.
to an earlier incident, am I clear to this, my lord? The notification for extending, they said that in 2015 they were appointed. Their provision period extended for another 2 years with white notification at serial number 287-288. Either this 287-288, prior to 285, it should have been there. I checked everything ins and out. I am not getting it, my lord. Now, very interesting. If you see at page 20, next page 20.
No, what I believe is, once these are recorded in the case diary, you always have the officer's notes. So I will write in the note sheet, and whatever document he has will be placed in the case diary elsewhere where a number is given. Because when you look at the case diary, in any trial cases, you look at the case diary, you will find that the handwritten note of the case diary by the IO here is in the last part where it is handwritten, but the documents are placed elsewhere. So a reference to the reference in the police diary may contain a different page number.
No, this is not a case diary. This is not a case.
No, whatever we,
Fine,
you
this
can
is-
see,
No,
I
I'm
don't have
understanding.
experience of the official file
No,
maintaining.
this-
But the fact remains that once the case diaries are maintained like that, obviously, when the note sheets and the files are made, they may say that the entry is made, refer to flag so and so for the document.
No, my lord, that's right. Your lordship is right. My lord, I've been experienced an AG of a Mizoram. I have seen how a file is maintained and how the notings are being made. I have not come across this type of noting. I have checked, doubly checked, I made it, my lord. And I have not found. Now, one thing I'm asking myself, it at page 20, this is a note sheet, this is a file noting. Now, how this 285, if you see at 285, serial number 285C, at page, how they can refer to a notification which is not yet been born, 287, 288, and already their services has been extended for 2 years. Hide notification at serial number, 287, 288. Where is that serial number? 287, 288. Not be. Now see at page 20, next page 20. See at page 20. Now, if you interesting, kindly see page 20. Please, this is a note of the Commissioner and Secretary. If you see after Rule 19, it may be stated here that the provision period of all the officers under Finance Taxation Department who were appointed on 2015 were extended for another 2 years by notification number FTX 117274 dated 5/1/2018, number dated 9/5/2018. So I checked here, my lord, if your lordship looks into it, from very top. See at page 3, my lord. See page 3. See page 3 now.
Yes.
Page 3, kindly see on the right, left-hand side. On top, you say FTX 115 of 2017.
Yes.
And see the date, 3/1/2018, 2/1/2018, lordship got it?
Yes.
Then 3/1/2018, PS to so and so.
Yes.
Then 3/1, all date, kindly see. This is 8/1/2018. Last. Kindly see on 3 to 8. Lordship got it? 3 to 8. 3/1/2018 to 8/1/2018. There is no note on 5/1/2018. See at page 20 now.
Serial number maintain koriye kon sab. These are the serial number which is serially maintained.
And they maintain, I have seen, my lord, they maintain the serial number. All serial numbers are being maintained.
Page number 15.
From page 15,
So just to demonstrate.
see that, see 115, page 15.
Yes.
See that page 15, my lord.
Yes.
All serial numbers are maintained. Serial number on the left hand side, serial number
208.
208 to 211C. Lordship got it? And see next, serial number 212 to 215C. Now, if you see that, next page, next page 16, see on the right hand side of the column, on the right hand side, serial number 216C,
Right hand side below.
right hand side below,
Bottom.
Yes.
bottom. 16, right hand side bottom, serial number 216C.
Yes.
The next is 17, serial number 217. And the right on the left hand side on the top, serial number 217, 284C, up to dash 284C. Now, if you see, now next
Next 285.
285, now it is 285. See at 19, 285. 19 on the left hand side column, which I have read, 285.
So they are maintaining the.
So they are maintaining the serial number. Throughout they are maintaining the serial number. And I don't know, my lord, when I looked into it, I thought that how they are referring something which is not yet born 287 to 80, and very interesting. I made it doubly sure. Let me check their affidavit in opposition. Maybe they have said, because the affidavit which has been filed by them, first affidavit they filed, my lord, April 2019, first affidavit. They have never mentioned that provisional period extended. Where in the notice, note sheet they have mentioned here. Now, second affidavit, my lord, which has been filed on 23/7/2019.
First affidavit is,
First affidavit
Item
is
57, 50, item 57. Item 57.
you want to see that one?
no, just tell us.
No,
the date.
that is filed in April 2019. First affidavit. It has date to blank.
The date we have to give is a
They
blank.
have not given the date.
It's
actually.
not given to the blank.
Date, bank, I don't know, my learned friend will able to say. 21st. That is para 14 kindly be mentioned, my lord.
Here you are saying what is not mentioned?
Not in mention the period of probation which has been extended.
Okay.
Because that is 2018. And they said that on the basis of office record, we have shown it and they should have mentioned it.
To mark to my paragraph 6. Answer.
Now, only my lord will kindly mark it to my read petition, page 222,
Paragraph 6.
paragraph 6. Paragraph 6, page 222,
I was the point of dim confirmation.
that my argument was on dim confirmation.
Page 222 of 96.
22 of 1996, 96, my lord, retapit. Retapit 96.
222 of 1996.
No. Page 222
Of
of
Retapit
writ appeal number 96 of 2022. Manaspati Malu, which was arguing on the first day, Malu. That's kindly see para 6, where my in the writ petition,
Para 6.
para 6. That's I said dim confirmation. And rule 22, but their reply reply in the first affidavit, please mark at page 247,
Para 14.
para 14.
It was filed in April 2019.
This was filed April 2019.
yes.
Now, if you see the second affidavit, what they said, now, para 14, my lord, your lordship will look into it, para 14 of that. And thereafter, the second affidavit which has been filed on 23/7/2019.
23/7.
23/7/2019.
Yes.
And
At page
at 278, paragraph 73,
again they have dealt with paragraph 6.
again they dealt with paragraph 6. These two paragraphs, first affidavit, additional affidavit, in the note, there was 2018, they said it was extended. But when I said dim confirmation in paragraph of my writ petition, they did not give any reply so far as the extension of provision period.
If it was extended in 18, they should have mentioned.
Because they said all these affidavit is true to my records.
Yeah, from official records.
From
that
official
time
records.
It was not.
So they could have mentioned it because this is of 2018.
Sir, later on. Next one, yes. Service rule or
I think this is what my service rule, a bit of argument I'll make on service rule, my lord. I have seen, my lord, by judgment, I have checked the Supreme Court judgment. My lord, there is judgment on, Supreme Court said each individual case has to be decided on each service rules. There are service rules. Here, taxation has got a service rule, AP has got a service rule, AC has got a service rule. You have to see in context of the service rule. Because I have seen two service rule extreme point. APS, my lord, there is no outer limit. 2 years is a provision and there is no outer limit. This is I have seen. And one extreme case, I have seen, what is Labor and Employment Department, where is at 2 years. The provision period is only 2 years. And in between APS, ACS, then taxation,
Not APS, ACS,
ACS,
taxation and other
taxation
transport.
and other transport, 2 plus 2. 2 plus 2. Service rule to Koran. What I have done, my lord, your lordship doesn't have to go through the service rule. I made a note here and I have quoted the service rule. Note kon dila? Ji sir?
Mr. S. Das, you can give a copy to Mr. Azarika and he can communicate to Mr. Kohli.
I thought that he is sitting for some other matter.
Oh, no, no.
Immediately I should have given to him. Honestly, I thought
I'm very grateful, Lordship.
I thought Mr. Kohli is there only. Kohli and my learned friend is there assisting. I never thought that my learned friend is there.
No, no, he's here. He's very much here.
Sorry.
Lordship, just as a from a procedure point of view, just to ask, is Mr. Das going to even argue tomorrow? Because I'm now in my head planning when I should come to party.
You should have come.
He's completing today.
Today itself you should have come.
He's completing today.
We will have opportunity to meet. I will be there for several days.
Yes, yes. Yes, Mr. Das.
Now this notes you will see. Milo, I said there are service rules. Extreme I have seen. Extreme is 2. Now I'll just kindly see my note, Milo. Once, Lordship got it?
But Mr. Das,
Yeah.
we may not be inclined to accept this submission at this stage because unless you show that this issue was raised before the Honorable Single Judge.
Which Milo?
And he still clubbed it and took it up together. That all the different service laws must have been, should have been taken separately. Because if that was not taken, then what happens is that there was a consent amongst the learned senior counsel or counsel for all the parties to enable the Honorable Judge to take up as in a single bench all the matters together. Because there was no demur.
No, this is
Just for only information, because I was there, Lordship.
no, that's not our
We
argument.
had filed a consolidated convenience compilation. Just no, I'm only assisting, I'm not arguing. A convenience compilation in the Kunal Das matter, in which all that was used by everybody. We served it on everybody because in that all the service rules, everything had been put in one place. So when arguments took place, that became the lead matter. And on the basis of that one convenience compilation and the written submissions therein, the case had been argued by everybody.
Yes. Briefly, this was touched by Mr. Ken Chaudhary.
Yes. What?
He had referred to this separate acts.
My argument will be different. I have seen that. I have seen argued. My lord, let us take for an instance of ACS. 2 plus 2. So now, what the service rule says, if your lordship looks into the service rule, suppose, my lord, I have been appointed as a provisionary for a period of 2 years. They can't say it's a dim extension has been given as a provisional. No. It has to be communicated in writing that for good and sufficient reason why your extension is given as a provisional. Like they said, 2 plus 2 is 4 years, 2 plus 2. So after 2 years you expire. So sometimes they communicate or otherwise they deem confirmation. So outer limit is 4 years. Now in this case, I will show, let me show the servicing.
Which one?
It provided that ACS. Now please look into that. Because they can't, even if they want to extend my service as a provisional, they have to, good and sufficient reasons. So that means they have to give in writing. They can't say, my lord, let's for an example, 2025, I have been appointed as a provisional. So my service 2027. So it expires in 2027. Now after 2027, they cannot come with an order after 6 months saying that, no, your services so and so has been extended as a provisional. They cannot come and say. On the expiry date, they have to communicate to me that for this good and sufficient reason, we are deciding to extend your provision period. It doesn't become a deemed extension. Like they say, it becomes a deemed confirmation after a period of 4 years. It cannot be. Kindly see.
Assam taxation rule.
See the Assam taxation rule 21.
Which I'm asking, read 96 of 22.
Lordship got it?
Yes.
21. Subject to availability of a permanent vacancy, a member of the cadre of
You're
superintendent
reading
of tax.
Which provision?
21. Rule 21. Provision and confirmation. Rule 21. Rule 21.
Yes.
Subject to availability of a permanent vacancy, a member of the cadre or superintendent of taxes and inspector of taxes shall be placed according to seniority on provision for a period of 2 years before he is confirmed against a permanent post. Provided, my lord will kindly mark this, provided that the period of provision may for good and sufficient reasons be extended by the appointing authority for any specified period not exceeding a period of 2 years. Lordship got it? So generally it is for 2 years before is confirmed against a permanent post. But if they want an extension of the provision period, then they have to communicate or they have to inform what is a good and sufficient reason that why you are extending your service as a provisional. So they cannot say it is a deemed extension of the service. Once I completed the period of provision and you don't communicate or don't write any letter to us, by extending our provision period, it is deemed to be confirmed. I am just handing over. Yes. Now,
There are two exceptions.
Yes, I said.
Please paramount.
now your lordship, I told your lordship there are two two rules which are extreme cases. One is an APS which doesn't have any provision for, there is no outer limit. And one rule that is employment service rule, no? Labor and employment. This has only a period of 2 years.
No power of extension.
No power of extension, my lord. Kindly see that.
And that is not here in this rate appeal. No one is here in this rate appeal. Do with labor and employment. I'm just demonstrating how the rule operates.
Only for the purpose of demonstrating before this court. Nobody is representing in this case. I am showing it before the court.
None of the candidates of
None of the candidates are here, but I am showing
rate appeal
extreme
petition is
cases.
pending.
That writ petition, of course, pending. I am showing the
Because
extreme
of-
cases. Now, if you see at 20,
Rule
no?
21.
Rule 21 kindly. No.
22.
22 kindly see, my lord. 22.
Labor and employment. rules.
Labor and employment rules, my lord. 22. Lordship got it?
Yes.
See 22(1). subject to availability of a permanent vacancy in the respective cadre, a member shall be placed according to seniority on provision against the permanent vacancy for a period of 2 years before he is confirmed against the permanent vacancy. A member of the service placed on provision under sub-rule 1 shall be confirmed against the permanent vacancy subject to the following condition. A, he has completed a period of provision to the satisfaction of the appointing authority. B, he has successfully undergone the training and passed the departmental examination, if any prescribed by government under Rule 19. If confirmation of member is delayed, account of his failure to qualify for such confirmation, he shall lose his position in order of seniority vis-a-vis such of his junior as might be confirmed earlier than him. His seniority shall however be restored on his confirmation subsequent. So here, my lord, it is for a period of 2 years.
And no power to.
And there is nothing is recorded here, no power of extension. No power of extension here. No,
ACS rule.
ACS rule kindly see.
APS.
APS, sorry,
Rule
APS, Rule 15
Just read it. Nale get that. Man khali pori dillo.
is an unlimited power. There is period you can go for 30 years. Provision is for 2 years. Thereafter, they can give extension. Rule that your lordship will file Rule 15. Well, I will just read 15.1. See the note, my lord. It is in the note. Second page, note. Just now I have given a note.
Yes.
Provision and confirmation. See the note. Assam Police Service Rules 1966. Lordship got it?
Yes.
Kindly see. All person, Rule 15, provisional.
Yes.
All person recruited to the service shall except person recruited under Rule 5.2 be on provision for a period of 2 years from the date of appointment to a service. The period of provision may be for good and sufficient reason be extended by the governor in individual cases by such period as deemed necessary. So,
No limit.
so there is no limit, unlimited.
These are two extreme.
So these are the two extreme cases. You all will find in the service rules. Now, if you see, now back to 21 of the
21 is 2 plus
in
2, like
taxation
ACS
department, it is 2 plus 2 in taxation department.
Yeah,
Next
ACS.
second. In 2 plus 2 and ACS also 2 plus 2. Transport also 2 plus 2. So there are 3 service rules. One is the ACS 2 plus 2, taxation department 2 plus 2, and the
Transport
transport is 2 plus 2.
Transport.
and other
plus-
services. And other services. Except these two.
So
All
except
2
these
plus
two, except these two Assam Police Service and the
Extended plan.
labor and employment,
All 2
these are extreme cases, my lord. And other is 2 plus 2. But when you want to extend my service on probation, there has been good and sufficient reason. You cannot say it's a dim
extension.
dim extension has been granted. If you don't do that, so my services will be confirmed because after 2 years, expiry of 2 years.
My probation period is 2 years.
So
Maximum
your lordship has seen that provision period of my case is 2 years. So once you don't communicate to me that for good and sufficient reason, your services has been extended, so automatically my services will be confirmed.
In confirmed. In APS it is written. In
For
other
this
services,
proposition,
it
you are
is
relying on these citations.
I'm sorry.
For this proposition, you are relying on these citations.
Yes, right. Lordship has seen this citation. Kindly see. I don't know how it is.
Since you have referred the paragraph, you may not read it because we have to rise at 3:30 for this
So,
single
all this-
bench.
Yes. Lordship has looked into it.
Yeah, should we go into the note?
Lumil notes is there. Your lordship
Because
can
we have
look
to rise
into
for
note.
at 3:30.
Yes.
So
Your lordship will go into the notes, you'll see. And my judgment, I referred to various judgment has been referred.
In between also and last page also I have marked.
See the last page, my judgment.
Yes,
relied
I've seen
upon.
Dharam Singh,
Yes,
Om Prakash Maurya,
yes,
Satyanaran Jawar,
yes,
Akbar Ali Khan,
yes,
Durgabai Deshmukh,
Hmm.
School, and
Bhel.
BHEL.
yes,
We have, you've given us a copy.
yes. And given a copy and also mark the paragraph also.
Mentioned in the note.
And note
It is relevant.
how it is relevant, we have mentioned in the note. Kindly see, my lord. Argument 1, I'll not read this. See, page 7, kindly see. Page 7.
Yes.
Page 7, argument number 1.
Page 2.
Now see,
2.
then what is the argument 2? Kindly see, my lord. Argument 2. Page 9, argument 2. Lordship got it? Argument 2.
Yes.
Then
Argument 3.
page 10, argument 3, my lord, only down below, argument number 3, page 10. Then argument number 4 is page 12. Page 12.
Yes.
12. Then is the conclusion, my lord, then judgment relied. And we quoted the rules, my lord, in page, it's starting from page 1, quoted the rules and
Facts of the case at page
facts
5.
of the case at page 5. Kindly mark at page 5 is the facts of the case. Page 5. Page 5.
Going to the note, reading the note, one page number mentions relevant paragraph quoted.
Yes.
In the notes, my lord, all pages, relevant paragraphs, everything has been mentioned. To make it more faster, I thought that we should make it. And my learned friend really worked hard and he made all the notes and the pages. So it makes more convenient for the court. I don't know, my lord, once I get it. But one thing I have to say, my lord.
Supreme Court judgment says rules have this rule.
But what the Supreme Court judgment I have ruled into it, the court has to look into the service, respective service rule.
Yes.
Respective service rule has to be looked into it. But if it is not that, yes, there are judgments also. There are judgments, he said that yes, there can be a dim confirmation. There can be a dim confirmation after the period is, but service every has to look into the service rule.
In the service rule, there is no deemed extension.
Now, in this, my lord, our case, my lord, there is no question of a dim extension. Where is that?
None of the service.
None of the service rule, my lord.
No deemed
Dim, they cannot take a point that it is dim extended. Once I complete the period of 2 years, my lord, as a provision, they cannot say that no dim extension is there. They cannot say it's a dim extension.
as decided in Dharam Singh.
So your lordship will kindly mark decided in Dharam Singh case.
In the extension line, and good and sufficient ground means it has to be in writing.
Well, your lordship is rising at 3:30. Only what remaining was there, this is over, my lord. That is over as fast as I can do it, my lord. I have this. Only what 15 minutes may be required tomorrow only in respect of 96. What I will show the last, because I have already covered, or because on the basis of tainted police investigation, I have read 2 arguments were left in tainted police investigation. I have given the note already.
Okay.
So only give 10-15 minutes, I will be over by tomorrow. Your lordship is taking the first half tomorrow or second?
It depends on, tomorrow again, there will be some disruptions, we don't know. The submissions of Mr. D. Das, London Senior Counsel, assisted by Mr. S. Das, London Counsel for the appellant in WA 333 of 2021. It remains inconclusive.
333 is concluded, man.
333
is completed 96.
Okay, 333 is concluded. So however, his submission remains inconclusive in WA 96 of
2022.
2022.
Yes.
Got the presence of Mr. Kohli along with his visiting counsel, Mr. H.K. Hazarika. Others who are present, may please give the names to the court master. Will record their presence. No other representative.
Lordship is again
It
sitting,
is
division
resumed.
bench,
Pardon me?
again sitting for a single bench.
Yes, for single bench, your very good friend behind you is there.
Oh, Master is there.
Uh,
That's why you always remember when we joined, Pathak, myself, A.K. Goswami, SSD. We were four, we joined together
Yes.
in the bar. And we in the old bar, and we did not dare to go walk inside court number 1 and 2. JP Bada
and
sir,
now,
he headed that.
and now two of you have, they are separate groups of two. Non-bearded and bearded.
We studied together also in the same college.
In the same college, but he was very meritorious. And I was not that. So I used to go to his home and trouble him. He said in law, he said, you have to study this 20 question. Don't give me 20, give me 10. So he used to mark.
Those days were very good.
Those days were good, right?
Yes.
Mr. President, this is part of matter 28. Right.
I'm deeply obliged.
Tomorrow, please inquire the time in the morning.
Yes, yes, of course.
Tomorrow is uncertain.
Yes, yes.
Monday.
Yes, madam.
Okay. Both sides are represented.
Madam.
On the prayer made by Mr. D. Bora, Honorable Counsel for the petitioner, matter stands adjourned today. List on 9th January and 9th June.
Deeply obliged.
Highly obliged.
Item 2 for hearing.
Yes. Mr. Pathak and Mr. Nayak, it's almost ready.
Long.
I'll now fix it for delivery of orders on Monday.
Launch.
You know that in the last division bench, we were referring to the notes.
Well,
Here, both sides, you and Mr. Nayak have cited the judgments of those paragraphs. A compilation of that paragraphs has come to 75 pages.
we can well understand what will be the condition on that side. But today I was seeing one beautiful, it's a beautiful, the thought process was going on in the first half case. It's a constitutional matter, in fact. Regarding a Nagaland matter, at home I was seeing it in my, important issues are involved in that case. It's a very important issue.
That is taking up a huge time.
No, that will necessarily take, it's not like an ordinary writ petition, but the kind of issues those are involved. I really got involved at, I was seeing the whole arguments from both sides. I love to hear this kind of challenging arguments.
No, that is in fact a unique argument which is going on.
Unique argument, and because here the adaptation laws will also come in, most probably.
No, adaptation laws will not come. this Nagaland matter is a matter which has a historic uh, chain of events.
But ultimately, beautifully said that land also includes this. They have got, there is an IRDA Act, this Act. That,
No,
this
that
so
is something unique. We never
unique
knew.
case I have heard. And
We never knew that part of the history. Nagaland is the only state which has come into existence by way of an agreement.
Agreement in 62, because our sir, the Pivotal sir, when he made me the government advocate of Nagaland for quite a long, your lordship is, he explained to me that it is not by way of like a accession of some princely
No,
states.
it's not there.
First to bring a, in fact, a common idea amongst different warring groups, then how the agreement happens. Sir would have loved to hear this argument today. I was remembering my sir also.
That's a unique part of the
Unique
history.
case.
Very rarely we find that argument.
I loved it because I still remember one day sir took me to Kohima in his car. Then he was explaining to me then how it all happened.
The submissions made by Mr. K.B. Pathak, Learned Senior Counsel, assisted by Mr. I. Kalita, Learned Counsel for the applicant, and Mr. P. Nayak, Learned Counsel for the respondent. Along with Ms. P. Barwa, Learned Counsel, is concluded. List all. Make it next Monday for delivery of orders.
In case I will try to come, in case I am absent also, your lordship will excuse me.
The act.
RPF.
Representation of people.
Lordship wants to see some proof.
Just a moment, there was something I just remembered. This 100D1,
100
1D1,
100D1,
100 subsection 1,
my lord.
D1,
D1, yes,
improper acceptance of any nomination.
yes.
And D4, by any non-compliance with the provision of the Constitution
Or the
or
of this
order. What is the distinctive point in this two?
improper acceptance of the nomination per se will not invalidate an election. It is preceded by the words that he has to plead that it has materially affected, as you also got it. That there has to be a pleading that improper acceptance led to the materially affected the result of the election. And suppose for the D, now I come to the D, there are many provisions of the Constitution, like for instance, suppose per assembly there will be one representative. Now suppose election is held, the 2 persons are elected, which will be in violation of the Constitution. But that also has to again say that that has materially affected. Because there is a difference between 1B, first your lordship will see the distinction between 1B, that any corrupt practice has been committed by a return candidate or his election agent or so and so with the consent of, here the materially affected issue does not come in. But D1, 2, 3, under D, there is an additional words called, if this situation happens, then it has to show that the result was materially effective. 1B, that additional requirement is not there.
So,
And there is another constitutional violation. Suppose the election has to be notified by the returning officer, Election Commission of India, but it is notified by somebody else. That will be violation of the Constitution.
okay. Snack,
Lordship, so far as my understanding is concerned, Lordship, section 100 are the grounds, Lordship, for declaring election to be void, Lordship. And D is one such ground, Lordship. 101 DI is one such ground.
One of the grounds.
So, Lordship, on if this ground is not fulfilled, Lordship, even on this ground, election can be set aside, Lordship. It can be declared void.
Now, at the end of the day, the grounds have to be specifically pleaded.
okay.